Yes, I just want to take this opportunity to greet you all participants and to invite you for this presentation. And the purpose of this presentation is basically to highlight some of the challenges that comes with an exam, which if due care is taken, those challenges can be overcome and you'll be assured of passing your exam. And therefore, the session is not per se a revision session, but a session where we just make a few assessments of what are the aspects that sometimes makes a brilliant and bright student to fail an examination which otherwise could have not been failed. Therefore, welcome on board. My name is Kenneth Mose. I've been a very close member with the CPA Rwanda, and therefore I want to again thank the management for considering me to share with you some of these few aspects which are critical to the passing of examination. On the onset, I just want to say that an exam is always an exam. And I can just say that there is no exam that is so hard, nor there is no exam that is so easier. That's why it's called an examination. And the purpose of this exam, as you are aware, is basically to test and to see whether that which you have been learning for a period of time, you grasp it and you understand. And that's why, therefore, it becomes important to point out to you some of the shortcomings that many of you go through, which otherwise leads to a number of people to fail. And if these shortcomings were taken care of, that will be overcome. And therefore, we are going to look into a few aspects of these shortcomings, and we'll be starting from the simplest. And the simplest is the examination instructions. So allow me now to take you through some of these aspects, and I just want you to be very attentive, as much as it may look to be the obvious. You know, when you are being told about the instructions, you feel like they are not critical for the passing of an examination. But I want you to know that those instructions that are given on the paper are so critical and they carry a lot of weight. And if you give them the weightage they deserve, then for sure, number one, hurdle will have been overcome. And therefore, I just want you to note that, you know, the examination paper carries instructions as the beginning. And you'll be surprised that even you have been given 3 hours and 15 minutes, but 3 hours have been fully allocated for people to go through the instructions. And therefore, those 15 minutes may look to be a lot of minutes, and sometimes some of the students, once the paper runs on the table, within 2 minutes, they have started to handle the questions. Now, that might not be the right approach. I just want to let you know that don't underestimate. Sometimes people underestimate, and you look at the paper, immediately you go to the question, you have not read the instructions, and you say, I want to minimize my time and undertake this. But you do not know what that question you are doing and what part does it form on the basis of the exam that you are going to undertake. And that's why, therefore, I want you to understand that the instructions that are given in an examination are so critical. They spell out what is expected to be done. They point to you what you're supposed to do. And once you are able to know what you are going to do, then it becomes easier for you to go to the paper knowing that which you are expected to do. And therefore, I'm asking for those who take exam instructions for granted, that take your time the moment you get the paper. The questions are for you. That's a fact. The questions are there to be answered for you. And therefore, at the end of it, you will look into them. But what you need to do, go through the instructions and get the information that is expected. You will find, for instance, that you'll be told that there are two sections. There is section A and there is section B. Maybe you will also be told that section A has got 3 questions and you are supposed to answer 2. Then you are told that among the 2, or yes, the 2, number 1 is compulsory. Number 1 is compulsory. And you'll find that that number 1 is carrying, for instance, for your case, around 30 marks. Number 1 is compulsory and it is carrying 30 marks. Then maybe from there, you may be told to answer 2 questions more or 1 question, whichever the case. But that now is information that you are supposed to pick from the instructions. Now, what normally sometimes happens, someone reads and says, answer 2 questions from section A. Now, that is part of the instructions. The other part, which says number 1 is compulsory, you did not read. You did not read it. So what you do, you look at those questions. If there are 3, you look at those one which you are able to handle. You pick number 2 and number 3, and you leave number 1. But remember, part of the instruction says number 1 is compulsory. And now that you have answered 2 questions, you have left number 1, which is compulsory. Now, I want you now to look into what happens when I get this paper as an examiner and I'm going to correct this paper. So, because I know number 1 is compulsory and you have not answered number 1, on the part which is to allocate marks, that part of number 1, I allocate 0 marks out of 30. 0 marks out of 30. I want you to mark that. And then in those numbers that you have done, I just pick one of those numbers, and that is what will be considered. So what does that mean? What it means that because you ignored that part of the instruction that was critical, 30 marks that you could have managed maybe 15 or 20, whichever the case, you have now lost all of the 30 marks. Now, when you lose 30 marks, remember you'll be remaining with 70. And then the question will be, what are your chances now? In other words, you have minimized. Instead of maximizing your chances of passing, you have minimized by just throwing away 30 marks, which otherwise could have not been thrown. So I want you to take heed that when you read the instructions, read them slowly, calm, because I want you to know that sometimes what makes many people to fail in exam is what we call panic. You just enter into examination and you start to panic. You want to look into the question, you do not know, and sometimes you do not believe in yourself. You feel like you did not revise enough, and therefore you come, mix up, and then you do not read the instructions, and at the end of the day, you end up doing that which is not desirable. And therefore, it is important that you take your time, read the instructions, take note. For example, you need to take note from the word go. You must be able to understand that by the time you start now looking at the questions, you are supposed maybe to answer 4 questions, if that is the case, or 5 questions. That must be clear in your mind. And in every section, it will be clear that maybe section A, you are going to do 2 questions, and maybe section B, you are going to do 2 questions. At the end of it, that you'll have done the 4 questions, if that is the case, as it is provided for in the instructions. And therefore, I'm just calling upon you that don't take these instructions for granted. They're important. They give you, the way forward on what is expected for you. And therefore, take your time, go through the instructions, read them slowly, understand, and then again, if you have read the instructions fully, I'll also advise that you take your time also to read the question slowly. As you read the instructions, consider also the question to be part of that instructions, that once you have read the instruction and you have understood the numbers that you are supposed to do, you can also take your time. Remember, when I'm saying take your time, I'm just saying that you have not started to write. You are just taking your time, number one, to understand what is expected of you in terms of the questions that you are answering. Number two, then you can go to the questions. In that section, you see how many questions are there, and out of which you are going to make a choice, so that you are aware that maybe in section A, there are 3 questions, number one being compulsory, then you'll be choosing between number 2 and number 3. Maybe now you go to section 5, also you find maybe there are 5 questions, and then you are expected now in those 5 questions, you take any 2 of your choice. And therefore, once you have that one clear in your mind, you can now even approach the question. You can approach the question and then look into the question before. And of course, when you are looking at the question, I just want you to know that when you are looking into the questions, you are basically trying to see those questions to which you have the answers at your fingertips, or those questions that you are, you know very well that you can handle. And in that case, you can now pinpoint that in section A, I'll do number 2 instead of number 3. Then you go to section B and you say, I will handle number 4 and number 5, if that is the case. And then if possible, you can mark those numbers in your booklet just behind. You can mark those numbers in your booklet behind. And if it happens that you find a number that you read, you have some information, and information that you may forget with time, you can start with that number, not starting the number, but you can go behind your answer sheet and you can note down the points so that at the time that you can start, those points are still written and you are not going to forget them. And that is an order in which you can go. If you find that there are some questions which are coming, you are looking into them, you have read the case study and you have seen what they are asking, and you happen to have that information at your fingertips, we advise that the best thing to do, taking your answer sheet behind, jot the points down so that those points at a later stage when you shall start to handle the question, they can be of help to remind you so that you can be able, because there are chances that while you are handling one question, as you try to look until you find that whatever that you had in your fingertips has evaporated and it is nowhere, and you start beating your head and wondering that this question, I knew it, now I've forgotten. The best thing, if you happen to have known, it is good that you jot down the basic points, and then they will help you as you work down. Now, I have already indicated, and I just do not want to go into details. I've just said, don't ignore, don't assume that you have read the past papers and you are aware of the instructions. Instructions may change, and therefore take your time. The other instruction you read, they were not yours. That one for the other people. Read the instructions that are contained in the paper that you are going to do. And once you have done that, then it becomes easier. You will be able to know now where to start. Now, I just want to skip for a moment the aspect of extracting the information from a case scenario, and I will return to it later. But I just want to tackle the second aspect of the instruction, which may not be seen as the instruction, but it is that bold instruction. It is about the time management. Now, time management is very critical in an examination. And in order for you to pass, time is so essential. The manner in which you shall use the time allocated shall be able to spell out whether you are able to attempt all of the questions, or you may attempt now two because of poor time management, and therefore you find that you have minimized or made a limitation into the probability of you passing. And that's why I just want to let you know that the manner in which you manage the time that is allocated to you, assume it is 3 hours. How are you going to distribute those minutes of 3 hours so that you give each question equal attention? And I have seen out of experience that sometimes many students do not really very much take time that serious. By the fact that you see that you have 3 hours, some they conclude that surely, what is that I'm going to write for 3 hours? And it seems to you that 3 hours is a long time that you can be able to write everything, even revise, and you will be comfortable within the time. That's not the case. That is not the case. The time that is allocated, if you could distribute the time that you have and distribute it, for instance, assume you are going to do 5 or 4 questions. Now, the 4 questions, what you do is you convert the hours into minutes. And of course, it is simple. It is 60 times 3. And you get 180 minutes. Then take those minutes and subdivide with the number of questions that you are handling. If you were to attempt 5 questions, if you subdivide, you will find maybe at most it's that 5 minutes. If the questions are 4, you subdivide, you may find maybe 40 minutes or something nearby. And therefore, what I'm saying is that the moment you have taken the numbers that you are going to do, just a simple thing, subdivide and be able to ascertain with surety that each question of the questions you are going to handle requires that 5 minutes. This is an example. I'm just giving an example. Requires that 5 minutes. Now, stick to the time. Stick to the time so that you have room to attempt all the questions. Now, the mistakes which has been done by many, and I just want to make this clear, the mistakes which have been done by many, as a result of panic, which I did make a mention, you find that the moment you are given a paper, without even reading the case study and understand, you go to the question, and then because you had read something related to that, you start answering. You answer, you almost attempt the question for 2 pages, and that sometimes it takes you 40 minutes. When you read the question again, you find that what you have written, what you have been writing is not what is expected. So you have already wasted around 40 and you have written irrelevant. And this I want to make you understand that in the experience of marking I have seen, then a student now cancels that number and then starts afresh. Now, if you assume you start afresh, the question is, how many minutes are you going to give to this question? Now, number one, by the fact that you have written irrelevant information or given irrelevant answer, and you have wasted maybe, sometimes the question with which many of you start with is a question that you are familiar with. Because that I know that you cannot start with a question that you are not sure. You start with a question which you feel strong, which you feel that you understand. And therefore, once you have taken your time and you find that you have been giving wrong information and already you have wasted maybe 40 minutes, that is where the panic pattern is now placed. And now you start sweating, you start, everything that you having get lost, and now you get confused. And that's why I said, therefore, don't make a mistake of jumping into the question. Go step by step. And that's why those things even are written from the beginning. You do not find instructions at the end of the paper, but you find instructions at the beginning of the paper. The time is at top. This paper takes this time. It is there. at the beginning, and therefore that is a sequence. Just follow that sequence. Don't jump. Don't leave the instructions, and you don't know the question is going to be done for how long. That is very critical. And I want, with the aspect of time management, I want to let you know that, of course, you are not allowed to enter into an examination with your phone, and therefore there is a limitation for you to know how many minutes you have consumed. And of course, assumption could be that invigilators could have been telling you time from time to time, but sometimes you may find that the invigilators are of the few that you understand, and therefore I could advise that you could, for purposes of exam, get a watch, get a wristwatch. Just go, put it down, and of course, once you have known that you are going to spend your 35 minutes, if you have kicked your paper at, assume, 9 in the morning, you know very well you have been given 15 minutes for maybe reading. You know now that at a quarter to 10, you must be fully out of question 1 and you are in the second question. And then you know also that in another 35 minutes, you would be in that order. If you handle the questions in that, what I want you to know is that by covering the minutes you have, you could have exhausted answering the question, if not fully, but to 3/4 level. And if you have dealt with the question to the 3/4 level, then you have created a chance that you are likely to get a half of the marks or more than a half out of the time that you have spent. And of course, that taking that assumption, then one thing that we look into is, if, for example, one of your assume 2 questions, I want to assume 2 questions have 30 and 30 marks, that is 60, and then another 2 have 25 and 25, then 60 plus 40. Now, and I'm saying, if you have attempted a question to 3/4, you are expecting for the question of 30, at least you have 15. And therefore, if you have 15 and 15 in 2 questions, you have 30. Then for the question that asks 25, if you attempt a half, that is 12 and 12. That is 24. So if you put 30 and 24, you could have gotten 50. And therefore, 54 actually, because 12 and 12 is 24. 24 plus 30, that is 54. There, you are at a better position. You are comfortable that that paper you have already passed. Now, what happens when you do not take into account the time? Now, this is what normally happens. One, you could find that you have spent 1 hour in one question. 1 hour in one question. Then you are now remaining with 2 hours to handle the remaining 3 questions. And therefore, you try and you find that the maximum you have managed to attempt 3 questions. The maximum you have attempted 3 questions. So a question with a full marks of 25 is gone. And as we said, you see, exam is an exam. There are areas that you may feel that you are comfortable. And when you have answered the question, when you return back home, you got your notes and you try to remember, you find that you did the opposite. So it is like another question has fallen. Another question has gone. One was not attempted. One, you made a mistake. And then maybe you have some 2 questions which comfortably maybe you may manage. Maybe you manage 115 and you manage 112. Now, if you manage 12 and 15, you are at 29. And you find majority sometimes of the people, you find them, they are at 35, they are at 36, and because of those mistakes. So we are here to advise you that the manner in which you are able to organize yourself and to allocate the time for the questions is so critical for your passing because it gives you an opportunity to handle all of the questions and to tackle all of the questions. And when you have tackled all the questions, you are sure that the probability, you raise the probability of your passing, and therefore it becomes very easy. Now, with regard again with time management, I just want to bring you an aspect where at every part of the question, because you know the questions have subsections, you find that there is question number 1, you find that section A has 2 marks, section B has 6 marks, section C has, in that order. And therefore, as good students, you need to ask yourselves, why are those marks allocated at the end of each question? Is there a correlation between the marks allocated and the time? That's a question you need to ask yourself. And the answer is yes. There is a correlation between the marks that have been allocated and the time you are going to spend. So if you are given a question which says list 2 legal positions, list 2. Remember, the word is list. And then you have been given 2 marks. Now, what you are supposed to list down, now as a student who wants to demonstrate, and sometimes some of the students want to scare the lecturer that they know, or the examiner that they know more. You take that question which is supposed to list, you spend 8 minutes or 10 minutes trying to explain it. Now, the question that I could pose, now, do you think the examiner will be concerned with the explanation when the question was about list or state? The answer is no. So that which you could have even spent 2 minutes or a minute at most, you find that you are spending your 10 precious minutes. That is a mistake, and that can lead you to failure. And therefore, those marks are allocated accordingly to guide you on what is expected. If a question has 8 marks, I'm just giving an example. If a question has 8 marks, it basically means that you are expected to write. And for that 8 marks, sometimes a full page and above is required. And therefore, there you will take time. But of course, the time that you are supposed to take in that question should not supposed to go beyond 7 minutes at most, as much as it has 8 marks. So that you have time now to go through other subsections in that order, so that the subsections put together, you do not spend more than 35 minutes or 40, if that is the case, in accordance to what you have done in terms of subdivision of those marks and allocating them to the questions that you are going to undertake. And therefore, I'm just basically saying that also the question, when you read the question, you will find the question in some cases is saying state 5 facts, state this or discuss. When the question is discussing, you know that that one requires you to write, but the one which says state or list, please list very quickly. If you have the information to be listed, list very quickly, because that is like an opportunity you are given so that you can move, and that time you take it to where a question requires you to discuss. And that is the best approach. And therefore, you will find that each question and every subsection, there is marks that is allocated ahead of it. Those marks allocated are there to guide you in terms of the times or the minutes that you shall spend in the question. And I've said it becomes irrelevant and unnecessary for you to use a question that has 2 marks and then you have written 2 pages, and the question has 2 marks. Sure, that one you need to ask yourself whether you understand what you are doing. Don't ever try to demonstrate to an examiner that you know much. That is not part of an exam. What you are doing is not part of an exam. Exam with instructions, follow the exam instructions as it is and do what is expected of you. Don't do that which as you have not been asked. Don't try to link what you are answering to something that is not related. Of course, you might be knowing that is good of you, but for the time that you are allocated, you do not have the time to demonstrate to the examiner that you know beyond. Just provide that which is required because there is a limitation of the time. And therefore, I've said that once you are making better use of time, there are chances that you could be able to easily go through the questions that is required. And then now the last part of this part of the time management, it is important that when you have read the questions together with the instructions, you have identified the question that you are going to start with. And of course, I want you to know that in an examination, there is no hard rule on which question comes first. There is no order. You decide that your number 1 will be number 6, that is it. And it basically means that to you, when you are looking into those questions, you realized that question number 6 is what you have more information. And therefore, as a good candidate, while you are going through the question and reading, it becomes very important that you rank those questions. You say, I have more information with regard to number 6, I will start with it. Then you maybe come and say number 3 is okay to me. Then, of course, maybe number 1, which comparison you find that it is the one which you are not sure. Then you can decide that number 1 will be last and number 6 will be 1. So that is the best way to start. And of course, as a good student, don't take a lot of time in a question that you are not very sure. Remember, all the questions are handled depending on how you are prepared. Of course, there comes a time when you find that a question has frustrated you, you try to read, you don't understand. So instead of taking that number and start to rethink what it is, please pick those other numbers that you are comfortable with, go through them very fast, because again, in that question that you have the answers at your fingertips, it is very fast for you to write because you know what you are writing, and therefore you will save a lot of time, which at a later stage you may now use to think on how to handle that question that you are not very sure. And therefore, don't take your time in the question that you are not sure, and then you are just thinking, taking 10 minutes to think when there are questions that actually you could have answered. And by wasting a lot of time, at the last minute, when you got to read maybe number 6, you find that it was the best and you had all the information. But you are reading when already you have been told 30 minutes to time. And that's when you are entering that question which you have the answers. That is a mistake. That question that you have the answers at your fingertips is supposed to be the first. And therefore, if you start with it, you will be the best, you will be better to go. And that is an element of time. And I want you to know that sometimes people take it for granted. And I've said, do not take the aspect of time management for granted. Try as much as possible to go to the examination with your list watch so that you have it to guide you, because I know that some of you, when you enter into the examination and the focus is in exam, you even don't hear when the time aspect is being announced by the invigilators. The only thing that you come to hear is that you have 10 minutes or you have 15 minutes and you wonder how time has been spent. And therefore, that aspect is an aspect that you need to take into account. It is serious. And of course, organize yourself. I say that once you have entered in the exam, compose yourself. The 15 minutes you are given is to bring about that composure so that you are at peace as you start answering the question and you are not sweating here and there, wondering what to do, because you have taken your time, you have read the question, you are organized, and you'll be better now to start with that organization in mind. Now, that having been said, I just want now to take you to the aspect which I escaped, and the aspect is how to extract the needful information from a case study or a case scenario. Now, I just want you to note that all questions that you handle requires what we call a critical thinking, or a problem solving skills. Now, you see, at the level of you being a candidate to be a certified public accountant, you'll be expected to solve the problems, really problems. And therefore, much of what you study will now require that you have the ability to apply the knowledge to solve a really problem on the ground. And that's why all questions are in a case study format. And therefore, you are given a situation, and then you are asked now, as a person with knowledge, what is the right position and what are the issues that are involved in the case study provided. And therefore, number one, you're supposed to read the case study well, understand. You see, sometimes I have seen, and I want to say this, a majority of the candidates, they read the question, then they start looking for the answer in the case study. And then, is that the right approach? The answer is no. That is not the right approach. There is no way you can read a question and then you go to a case study. No, that is doing it in the opposite, and then you are likely to be misread when you go to the case study, and sometimes you see like you have seen an identical answer, and therefore you carry or you just quote that which you have seen, because you did not read the full case study and have it in your mind. Then you are answering what we call hypothetical questions, which at the end of the day may not be satisfactory. And therefore, as a good student, the first thing you do, go to the case scenario, read it. And I want to say this, the aspect of the case scenario, to many, they see that it complicates life. It makes things difficult. And sometimes what is easier is construed to be very difficult. That is a perception. That perception, I want, again, as we discuss this, I want you to remove that perception that the case scenario is very difficult. There is nothing that is difficult in a case scenario, because just a case scenario is something that you are given a kind of a development that you are being given, and out of it, you are able now as a candidate to be able to pick the issues that are raised. And once you have picked those issues, before reading onto the question, you will go to the question and you'll be surprised that those issues that already you have picked out are the issues that they expected for you to answer. And therefore, there is nothing that is complicated in a case study, and there is no way out, because each and every question that you shall tackle has that case study or case scenario. So there is no any other way. There is nothing like, oh, you now avoid those cases or those questions with the case study and do those. Everyone asks. So put your mind that you must tackle the case study. You must tackle the scenario. And therefore, Now, the most important thing, you may find, of course, a case scenario. It runs maybe to a half a page, sometimes to a quarter a page. And of course, sometimes it's like a story. And therefore, in that story that is given as a background information, you need to be able to be in a position to pick that which is important and to avoid that which is not necessary. And therefore, when you are reading, you see sometimes you will find that if it is a case study, we may provide that this company ABCD is a public limited company, or ABCD is a private company. Of course, the private company, if it is in relation to what you are going to be asked, then the aspect of private or public becomes critical. But sometimes you find that those names are given, and at the end of the day, they have got nothing to do with what you are going to be asked. And therefore, don't start underlining public, private, and all of those by shares or by guarantee. Those may not be necessary at that time. And therefore, we are basically saying that when you are going through your case studies, characters may include the name of the individuals in that case study, or the places, or the district, or the province. Those may not be very necessary. Now, the necessary thing is basically to see what is being brought out. What are the issues? What are the real issues? Because the name of the district, the name of the company, the individuals who have shares and all that may not be very, very critical. But what is critical is, where is this information heading to? And therefore, it becomes very necessary that you do not want to start to read. If the district is Ruamagana, you start saying, why Ruamagana? Why another district? That's not critical. That's not critical. Don't continue to worry yourself about the district. Don't continue to worry about the names. Just be concerned, read consistent, where there are commas, look into them properly, go down, get the information. Get the information. And as you get the information, as a good candidate, you will be in your mind, you will be in a position to say, sure, this case study is coming from chapter 2, and maybe it is dealing with A, B, and C. Or this case study is coming from chapter 5, and it is dealing with this. That is a good candidate. You try to orient your mind, and you try to pick, because there are issues that are coming out, and therefore you start looking into what are these. Then, of course, as you put this into the mind, once you have read the case study and you are comfortable with it, comfortable means you have followed it, you have understood it, and therefore now you have already even identified the area. Now you go to the question and you see whether the question will confirm that which you have already read. And of course, when the question confirms what already you have identified, then you find yourself more positioned, more stable, because the information you have gathered, the relationship that it has with the question, you are comfortable that this is from this chapter. And of course, your mind now will be rekindled and will be taking you through that part, and therefore you'll be better to go. And therefore, I've said, ignore information that is very unnecessary. Filter the information. That's what we are basically communicating. Filter the information. Go to the specifics. Go to the problem. Identify the problem. And therefore, ask yourself, if this is the case, now, how could I have helped in this matter? How could I have solved this problem? That's what we basically, as examiners, we want to see, how students could put themselves in a situation that requires guidance, and they can be able to guide accordingly. And therefore, once you have identified the important information, of course, I've said you have already related the information to the given chapter. And of course, when you go to the question, you go to the question just for purposes of confirmation that you are walking in the right path, and therefore you are good to go. Now, that is the part of extracting information, and I've said you cannot ignore, and therefore take your time, read and understand. The language which is used at many times is not complicated at all, and therefore don't start to imagine that the information that might have been provided is not easy. It is easy. Just read it as it is, get the information, and then go to the questions and see that which is required of you and how you can be part of the problem, how you can be part of the solution now, how you can bring about a solution to the problem. Now, I just want to go to the last part and final part of the aspect of what is expected of you, and the part of now past papers. And the aspect is, how do one revise past papers, and what is the relevance of past papers to you as a candidate who's going to sit the exam. Now, I just want to, from the onset, as I deal with these aspects of past papers, I want you to take note that it is revision. It is revision. The word to revise basically means you have already read. You have already read. And therefore you are going through, you are just going through to confirm that which you have read. You are just going through to confirm that which you've read. Now, for those, I've taken note of those who want to have the right to participate. I will, at a given point of time, I will ask that at a given point of time, I'm going to pause, and then we can, I can give that room so that you can ask that is of concern. I don't know whether there are many who cannot hear me. If you cannot hear me, then of course just let me see, because I'm going through your concerns through the chat. And if there is a concern, especially with the sound, then I will, if it's a common thing, then we can be able to see how we can deal with it, So, but if you can hear, then of course we can try, and at a given point of time, we can have a session in which I can give you room for you to ask questions that may be of concern. But for the time being, I just want now to continue with the aspect of how to revise past papers. And I've said that past papers are supposed to be revised to affirm that which you have read. Basically, to let you know whether, if you are to be one sitting on that paper that you are revising, how could you have performed? How could you have performed? Because it basically tells you you have read, you have the information. Now, when you go through the question, you read number one, you say, oh, this question I would have answered. The answers are this. Number two, in that order. It tries to give you the confidence that you are also in a position, if that could have been your paper, you could have sat for it and you could have passed. That's one aspect. The second aspect that I just want to let you know, there are some candidates, some of you, you don't read, but you go and pick the past papers, and if possible, with the answers, and therefore they become the basis of your materials for your exam. That one, I'm telling you, it is a very wrong approach and it will not take you anywhere. Because the assumption that if you revise the questions well, you are going to get similar questions, that one is a wrong assumption. That is not the role of the past papers. The past papers are not there to guide you to spot another question that is going to come. If by chance you find a question that will be similar to another one, that is a chance. And of course, you know, the game of chance is dangerous. And therefore, the best thing now for you to do is, number one, read the materials provided. Have the basics, understand. And then, when now you are going to the question paper, the role that the question paper has is, number one, chances are, if these past papers were not to be there, when you are given that when you are given your paper, your examination paper, you will be very surprised. Hey, is this how an exam for CPA looks? That will take your time looking at it, wondering, and that will have taken your time. So to eliminate that aspect of imagination on how a paper that you are going to sit looks like, you are given past papers so that you go through it, you read, and you have the psychology of the examination. You know that what you are going to do is not so different from what has been done by others and what is in the past papers. And therefore, having seen these past papers, it gives you confidence, and you know that what you are going to see is not so different from what you have seen. And therefore, you are given an opportunity to have a paper that looks like what you are going to be given. And therefore, it is not different. That's number one. Number two, past papers take you through the minds of the setters. It takes you through to the minds of the setters. It basically gives you an opportunity to see what guides a setter to come out with a given number of questions. And therefore, you can be able to start saying, okay, those which are obvious have not been tested. Materials where there is no complication, there is no much of testing. But where there is some complications, you find that there are questions from time to time. And therefore, you mark and you say, okay, this is how an examination is set. This is how the examiner thinks. This is how he goes about. And therefore, you are given in advance an understanding on what is expected. And therefore, that understanding, if, for example, there is a chapter that you had read and you are not comfortable, and when you are going through the papers, you will find that every now and then there is a question from that chapter. It tells you that that chapter is a critical chapter, and therefore you need to understand, because another question, because remember, it will not be the same question, but questions are coming from the same chapter year by year, session by session. And therefore, it tells you that this is a critical area. Do I understand it? And if you do understand, then of course that past papers has guided you to be able to become. If not, then you are supposed to say, this part I need to relook, because if it is a place where questions are coming from time to time, then of course the past papers has helped you to take you back so that you have that understanding. Then the other aspects of the question paper is basically to show you how marks are distributed, because you'll find that it is almost a common a common thing that there is no deviation in terms of how those papers are set from time to time in terms of the distribution. If it is a question with 30 marks, the distribution will almost be the same. And therefore, you come to understand and you see, because if you are such person who reads a section of a given chapter and does not read the whole chapter, you'll be surprised, therefore, that you'll find that there are questions that are covering almost every aspect of a chapter from the beginning and to the end. And therefore, there is no way that you can only read a part of the chapter and you leave another part. And therefore, that gives you an opportunity to have that understanding. And at the end of it, having been guided in that way, above all, you'll be now dealing with these past papers as an affirmation of what you've read and what you've understood. Because when you read, for example, maybe a question of 2021 in the month of April, you read them, you say, oh, this paper, if I could have sat, I could have passed. You go to the one of August, you say, wow, this I could have. Then, of course, that level of confidence is good, and it takes you into the examination in high spirits. And when you go to the examination in high spirit, then of course you are positive, and indeed you can be able to handle. Now, on the contrary, if when you take a paper, maybe of 2020, look at it from question 1 to question 5, there is nothing you could have answered. Then you take another paper of 2021, again you find there is nothing you could have answered. Then you take another one of 2022, the same. Now, that tells you that your level of preparedness is down. Your level of preparedness is down. And therefore, if you have time, it basically means that you have to burn the midnight oil to catch up. That is how these past papers can guide you, because you cannot go to one paper, you know nothing. You go to another one, you know nothing. You go to another one, you don't know anything. Then you expect that now the examination that is going to come, you will know. How? How? That is not going to be possible. And therefore, these papers are there for a candidate who has read the materials provided, and therefore you now have the opportunity towards the end. Normally this revision happens towards the last week, for your information, for the last week, so that you can sit for the examination. But you cannot take 1 month, 2 months revising first papers. No, you're supposed to take your much time to conceptualize the concepts that are found in the chapters. Be very familiar with each of the chapters and the issues contained, so that now when you go to the past papers, you basically try to see how do you handle those issues on the basis of the knowledge that you have acquired from your study materials. That is how these past papers are critical. And therefore, I want you to know that once you have taken these past papers, because one could ask, where do you start from? Do you start from 2015? Do you start revising from 2018? And therefore, the question is, what is the relevance of you revising the past papers? And therefore, my advice is basically, you do not need more than 5 papers. You do not need more than 5 papers. I'm just saying, if you have taken one paper for 2020, you just pick 120, any session, pick another one for 2021, pick another one for 2022, maybe pick another one for 2023. Those are 4. Revise those 4 papers. And best careers have said you are not revising so that you are revising an exam. No, you are not revising an exam because there's no way that the exam of maybe 2021 will be the same as the one of 2024. That one, just put it aside because that one will never happen. And therefore, the essence of these past papers is basically to give you that overview of what you expect. Number two, it tests. You use it as a litmus paper to test that which you have read because the chapters are the same. And the issues which had been raised in the previous examination are contained in the study material that you have been reading. And therefore, when you read the question, do you find that you have the answers? When you go to the second question, do you find you have the answers? And therefore, when you go through and you find that if you could have tackled any of the 5 questions provided, you could have been in a position to pass, then of course, it gives you morale. It gives you confidence that that which you have read, you understand because you can apply it in these past papers. And therefore, it takes you to the exam being better prepared, being confident than it could have been when you could have not seen a paper and you see the paper for the first time when it is put on your table during the time that you are going to sit the exam. And therefore, I've made it very clear that don't put a lot of energy. Don't put a lot of energy in the question papers. You read each one by one. That one may not be important. As a good student, you can basically maybe take those questions and you can be able to analyze and see what is that is common. What is that is common? And it will come out. You'll find that a given chapter at even any given time, you will find it. And therefore, it tells you that you need to go to that chapter, understand it, because you may not know whether a question, not similar question, a question, I've not used similar, a question may come out of such a chapter. And therefore, with that kind of information, it basically tells you that don't dwell too much on these past papers so that you start revising from 2014, 2015, 2016. Those are also, that is a booklet of its own, and you may not have the time for that booklet. Just take a few questions as just a snapshot for guidance, for affirmation, and for you basically to get used to the language of the examination and the manner that the exam is set, so that when you sit for your own examination, you do not find anything which is new other than that which you have seen from time to time. So that is it. Now, having said this, I just want to go into the scenarios so that we can be able to pick that which we have discussed. Because I've said that scenarios or case studies are common and there is no question without it. And therefore now, I just want, maybe for the time that we'll have, I want us to try and see how we can be able to pick the right information and be able to apply. And of course, my case scenario or case study with their questions, we try to see how they are solved. And therefore, if you are able to see the screen shared, which I am sure you are able to see, you can see, for instance, we have APC Limited, being a private company limited by shares, was registered in Ruamagana District in the year 2013. It has 12 shareholders with different types of shares, but many of them have ordinary and redeemable shares. Now, for the registration of APC Limited, the shareholders submitted to the Registrar General Office necessary documents such as the Memorandum of Association, the Articles of Association, and the Power of Attorney. They applied to the Registrar General to carry on business of farming in Ruamagana district, and it was well detailed in its Articles of Association adopted by the General Assembly that no any other business that will be carried out by the company. Now, for the 2 years of operation, ABC Limited increased its assets, and among them were 20 hectares of land located in Muanga district that was projected for construction of processing factory. Now, when the pandemic, that is the COVID-19, broke out in Rwanda, different activities were suspended to cap the spread of the pandemic. Now, the directors of the ABC Limited took a decision to take a loan of 50 million francs from a bank, and the money to be used for the exploration of the mining of minerals in the concession of Ruamagana district and the land purchased in Muhanga. Now, the directors hoped to repay the loan using the money from the sale of minerals, and the surplus would cover company administrative costs. Unfortunately, 20 million Rwandan francs invested for mineral exploration was lost because the mined minerals could not be exported as various borders were crossed. When one of the shareholders, Wamahoro, received the information that the company had invested in a business not recognized by the Articles of Association, she requested for a General Assembly to discuss the above development and the laws for the company. Now, if you have followed the case study, as a good student, you could be now reading Is it common to you or that you are not seeing the screen, or it is one person who's not seeing the screen? Because my screen is shared, and I believe that it is being seen because I can observe that there are 67 members, 67 participants. If it is a problem of one, try to troubleshoot, try to see your internet, because your internet may be the one which is a problem, and that's why you may not be able to see the screen. And for the rest, if you are able to see the screen, well, now we are in the first case study. And of course, as I said earlier, our major concern is to pick issue or to pick really issues of concern. Now, if you go through, as I did indicate when I was saying how you extract important information, you find here the name of the company, the number of the shareholders, the shares they had, the business of the company, and how the business went down, and how they decided. Of course, earlier the business was doing well, and as a result of the business doing well, the company acquired some more assets, for example, land. And then, of course, as it was progressing, they decided that they should be able to move to another business of mining minerals. And therefore, the directors of the company went and took a loan, and they invested this money in the business of exploration of minerals. And unfortunately, because of the pandemic, the COVID-19, they could not succeed, for the borders were crossed everywhere and exportation had become very difficult, and therefore there was a loss that was occasioned to the company. Now, the question that you need to ask yourself is, what are the issues that are involved here? Because we are seeing one of the shareholders basically saying that, was it right for the company to have invested the money borrowed for this business vis-a-vis the requirements of the Articles of Association? So now we are basically taken into the Articles of Association, and more especially on the object clause. What is the purpose of the company before us? Was the business of mining related to the main business of their concern? Those are aspects, of course, which come out before we could be able to answer the question. And therefore, for the interest of one who has said that we go through again the case study, because it is very critical, this is where now the gist of all the matter is. And I just want again, we go through it. And the case is ABC Limited is a private company, limited by shares, and it was registered in Ruamagana district in 2013. It has 12 shareholders with different types of shares. However, many of them have ordinary shares and redeemable shares. Now, of course, for purposes of registration, the promoters, all the shareholders, had provided the office of the registrar company with the memorandum of association, the articles of association, and of course the powers of attorney. And therefore, they had indicated, of course, within the articles provided, the articles made it very clear that the major objective of ABC Limited is farming. It is farming. And this is well detailed in the articles of association. And then the very same articles of association says that other than this, there is no any other business to be carried out by this company, ABC. Now, take note that for the 2 years of its operation, the company was doing well, for it increased assets, among which were 20 acres of land that were both located in Mwanga district. And this was projected to be for the construction of a processing factory for agricultural products coming out of the business of farming. Now, of course, because of how the company was doing, we are basically seeing that, of course, there was the breakout of COVID-19, and this, of course, affected many businesses. And of course, those things that were done as normal were suspended. In other words, much of the farming, much of the meeting, they were suspended. Now then, of course, in their own thinking, the directors decided to go for a loan and engage themselves in big ventures. And these ventures were to explore the minerals under the concession in Ruamagana district. And of course, they tried to see also whether they can do that in the land bought in Mwanga. Now, of course, when they took this loan, they felt that the new business which they were to start, were to do well. But unfortunately, the company suffered a loss of 20 million invested in this venture, because whatever that were mined could not be exported because of the curfew on the basis of the pandemic. Now, one of the shareholders, Wamauro Iya, was informed about the loss, and therefore he was very concerned whether in the first place were the directors of the company right to invest in this venture, which was not within the articles of association. And therefore, when you read through, you'd be able to pinpoint, and that's what I've said, that the issue is more on the core business of the company, and the business of the company is found in the memorandum of association and partly in the articles of association. Hardly in the articles of association, which is basically rules governing a company. Especially what is that is able to do, and what is that is not able to do, and what is that which can be done with permission, and what are the procedures. That is what is found in the articles of association. And in this case, things that were not provided for in the articles of association were undertaken, and therefore resulting to a loss. So we are basically now, the issues there is aspects that have been done outside the memorandum of association. The question we ask, assume there was no loss. Assume there was no loss. Were the directors of the company right to engage themselves in a business outside the memorandum and the articles of association? That's the number one. Number two, now that they invested this amount in a business not within the memorandum and the articles, is this a loss to the company or a loss to the directors? Those are questions that you have to pick out of this case study. Now, we have not read. Now we go, having already, remember, we have raised those issues, and the issues have touched already on the memorandum and on the articles of association and the powers given to the directors. Do they have power to do that which is not authorized in the memorandum nor in the articles? Those are questions. Now, required. Now that is the question. Assuming you are one of the members of the company, what is your legal opinion on the issues raised above? What is your legal opinion on the issues raised above? Now, what are the issues? I've already made a mention of those issues. I've said, number one, there is an investment done outside the main object of the company. The main object of the company is farming, not mining. Mining is not related with farming. That's number one. Then number two, the loan that was taken, of course we could ask, were the directors having that power to take the loan? And if yes, did they have the power to invest in a venture outside the main objective? The number three, whose loss is this? Is it the loss of the company, or is it the loss of the directors? Now, of course, to answer that question, the first thing is the directors of the company did not have power to do business that is not contained in the articles of association and in the memorandum. That's number one, because these are living documents that govern the company. The company, not being a human being, it is being governed by these documents, and therefore they did not have the powers, number one, to act outside the articles and the memorandum of association. Now, of course, having said that these are living documents, it's important to note that the memorandum and the articles of association have the effect of a contract and are binding as between the company and the shareholders and the members and between the shareholders or the members themselves. And therefore, if the directors of the company are working on behalf of the members, then of course they are bound to be guided by the articles and the memorandum of association, which is a binding contract. And therefore, the powers to act in a manner that they acted was beyond them. And therefore, they did not have the rationale for them to invest in a venture that was outside the memorandum. And it is important to note that even if there was a general assembly to validate what was done, it could not have happened by the fact that this was not contained in the memorandum nor the articles of association, and therefore the transfer or the amount that was used in the investment of the mining was outside the powers, and therefore the directors did not have the capacity, the right, nor the power to act or to do anything that is in contravention of the articles and the memorandum of association. And therefore, as we have seen, the second part is that already we have seen that there was a financial problem. We have dealt with the first thing, and I'm sure you've heard what I've said, because the question we were asking were the directors of this company had power to engage and to use resources that are supposed to be meant for the farming for another business? The answer is no. Now, the loss which was occasioned, was it the loss of the company or was it the loss of the directors? And that's now the second part that we need to look into. And that second part says ABC Limited defaulted to pay the loan, and the bank started the formalities for filing the case before the court against the company, and the General Assembly took a resolution that the bank should sue the directors themselves because the investment is not recognized by the Registrar General and its articles of association. And therefore, as a candidate of company law and probably a worker in the bank where the loan was taken, do you think that the resolution of the General Assembly is legal? Justify your answer. Now, of course, remember, I've made a mention, and I just want to mention this as we handle this. You know, at a given point of time, whatever that was done was a contravention of the memorandum of association and the articles of association. And at the later stage, therefore, after the investment, there was a meeting, a General Assembly, in which a resolution was passed, which to the effect that surely these directors were for the good of the company, although the loss has been undertaken. And therefore, it's like they ratified, they said, okay, they were working on behalf of the company. That's good in one part. But there is a second aspect, that there is a loan that could not be paid, which required to be paid. Now, a company is supposed to be taken to court. The question that we are asking, is the company reliable for the action of the directors, or are the directors going to be reliable for an action they undertook outside the memorandum and the articles of association? That's the question. And you can see that the marks that are allocated are 3 if you are able to follow. For those who are not able to see the screen, I still continue to ask that I don't think that it is a problem of majority. And if you are not able to see the screen, try to troubleshoot, and maybe you may be having a problem of connectivity, network connectivity. For those who would want to participate through speaking, I want you to know that I'm an invited member, and therefore I'm just in. The host maybe could be able, maybe, I don't know how, whether the host can allow that so that you can be unmuted so that you can raise the concern. So that's the match, because I'm a panelist, I'm just invited, and therefore that permission of allowing interaction I do not have. That's why I suggested that you keep the concerns you have. The screen is there. We can return to it. You just mark the question, and therefore I want that this is 2:30. Maybe at 4 or 4:30, I could, with the permission of the host, that we can open up for interaction. That's the suggestion I have, and I'm sure maybe the hosts at a given point of time, they can be able to respond. But for the time being, let us try and handle some of these concern, and of course the expectation. If you are the one to have sat for that paper, what could have been your response? And of course, the question we say at this part, we say that there was a resolution that had been passed to the effect to legalize what had already been done, and therefore there is a need of paying what has been defaulted, what was being borrowed, and therefore the question we have asked, who is responsible? And was the resolution that was passed in the General Assembly legal? And the answer is, number one, no, the resolution of the General Assembly is not legal. And of course, we are basically, I want you to get the reasoning. The reasoning is simple. When the articles and the memorandum of association have been put in place, and the memorandum and the article spells out the nature, objective, and the manner in which the company is supposed to operate, unless to the contrary will mean that again there is a General Assembly that comes, sits and discusses, passes a resolution, gives the directors the power, expands the scope of the business, and then from there, they can now, with that permission, they can now go into the field and start this business. But for this case, you find that there was no resolution. There was nothing that gave them the powers. And now, therefore, that they had done something which is illegal, that illegal thing cannot be regularized by a meeting. To the effect that resolution that was passed has got no effect, because whatever that was done by the directors did not have a legal basis, and therefore the resolution cannot give it a legal basis. Now, the second part. Did the directors act within the articles and the memorandum? The answer is no. Now, it is only the articles and the memorandum of association that links the company to the members. And therefore, the action of the directors were not the inaction of the company, because the company had mandated these directors to invest in farming and farming alone and not in mining. Now, diversifying the business of the company without the permission of the owners who are the shareholders is contrary and against the law. And therefore, they were not acting on behalf of the company to which they are the shareholders. And therefore, it is assumed that they acted on their own self-interest, and therefore the loan that was taken was not the loan of the company, but the loan of the directors, and therefore the directors alone are supposed to be taken to court. Now, going to that, we read the article of the law, and Article 27 of the law governing companies in Rwanda, as the law of 2021. It basically says that a company or a guarantor of an obligation of a company cannot assert against the person dealing with the company or with the person who has acquired property rights or interest from the company that the articles of the company have not been complied with. And of course, we are basically saying that the law says that no person can be allowed to escape where he has asserted to have used powers which he did not have, because those powers are provided in the articles and the memorandum, and therefore this person alone shall be held reliable for the property so diverted. Now, of course, that is the first part. Then, of course, another question with relation with the same case study is to discuss any two situations when a person dealing with a company cannot be considered to have asserted himself against the person. In other words, when you take a loan from the bank, we are basically the assumption here, notwithstanding the articles of association and the memorandum, is like the directors were acting on behalf of the company. But the action on behalf of the company could have been complete if it was in line with the memorandum and the articles. And therefore, the assumption is that they asserted to have taken a loan on behalf of the company when they did not have such powers to do so. And therefore, the question that we are being asked is, what are two situations when a person who's dealing with the company can assert to have acted on behalf of a company? And therefore, the response is simple. The answer is simple, that a company or a guarantor of an obligation of a company cannot assert against a person dealing with a company or with a person who has acquired property, rights, or interests from the company. That's number one. The articles of association of the company have not been complied with. Number two, a person named as the director of the company in the most recent notes filed with the Registrar General. Now, a person named as a director of the company, the most recent note filed with the Registrar Direct, is not a director of the company, is not duly appointed, or does not have authority to exercise power which a director of a company carrying on business of the kind carried on by the company customarily has authority to exercise, or a person held out by the company as a director, employee, or agent of a company has not been duly appointed, does not have authority to exercise power which a director or employer or an agent of a company carrying on business of the kind carried on by the company customarily as authority. Now, the question now we are asking here is, at what point of time can an action of a person acting on the capacity of a company can be accepted as binding? And we are basically saying that, yes, if a company, and in this case we are looking into the loan which was taken, the directors took a loan for the company. And therefore the question was, what was the purpose of the loan? To invest in the exploration of minerals. Was that part of the articles of association? The answer is no. And therefore this person cannot be accepted to act on behalf of a company. The reason is, what they did was not in compliance with the articles and the memorandum of association. Second, a person named as the director of a company in the most recent notice filed with the registrar. Of course, it is one thing to mention a person as a expected, and therefore the moment that person has not been confirmed nor appointed, nor does not have the authority to bind the company, then such person cannot be accepted to claim to have acted on behalf of the company. And of course, any other person who may act, either it may be a director, it may be an employee, or any agent for that reason. If that person has not been given power, nor does not act in accordance to the documentation or the documents of the company, that is the articles and the memorandum, then that person cannot be allowed to say he has acted on behalf of the company. And therefore, a person held out by the company as a director or an employee or an agent with authority to exercise the power which a director or employee or an agent may undertake, it must be that he is acting within the powers that is provided. And therefore, a document issued on behalf of a company by a director or an employee or an agent of a company with actual or usual authority to issue such documents is not genuine or not valid. So we are basically dealing with the aspect whether the company will be responsible to pay this loan, and the answer here is the bank cannot file a case against the company, but it can file a case against the directors. And of course, the other aspects here that we are raising is that this is a subsection of the case scenario. Now, this subsection says that the bank filed a case against ABC Limited for recovery of the loan of the 50 million and its interest to the Commercial Court of Nyarugenge for the summon and the notification of the case filed to the court against ABC Limited was sent to its branch of Nyarugenge, informing the company to respond to charges within 15 days. After 15 days, without the response from ABC Limited, the case proceeded in absentia, and the court ordered ABC Limited to pay the bank a sum of 60 million Rwandan francs. And then the question discussed the legality of the judgment on the case without the presence of ABC Limited before the court, based on the procedures of summoning and notification made on the case. Now, of course, as good students, you could have asked yourself, where do you find this information? Or have you read this kind of information anywhere? Because now the question is, there was a procession in a court, and the company was taken to court, assuming it was careless. The charges were read, the company was not there, the case proceeded, and then finally, the company was told to pay 50 million, which was taken as a loan, and 10 million as interest. And therefore now the question is, discuss the legality of the judgment on the case without the presence of APC Limited before the court based on the procedures of summoning and notification made on the case. And therefore, the response is very clear that the judgment of this case without the knowledge of ABC Limited was not legal because it was not summoned as provided for by the law, which should be in Ruamagana district where there is the registered office, because their absence from court is on the basis that they were not aware because summons were served in a wrong place. And that one we find it in Article 1 of the law of 2021, which provides that any communication, any notice, any legal process, any proceedings are served on a Kanban by, number one, personally serving to a director or the Kanban secretary. Number two, if it has to be sent, it must sending it by registered post to registered postal address of the Kanban or sending it electronically. Three, leaving a summon at a registered office of the Kanban. Four, delivering to an employee of the Kanban at the Kanban's head office or principal place of business. Or in accordance with an agreement made with the Kanban. Or number five, by serving it at an address for service given in accordance to the rules of the court having jurisdiction in the proceedings, or by such means as an attorney acting for the Kanban has in accordance to those rules, stated that the attorney will accept the service. So the question here basically is, we have progressed, we have seen how the directors acted beyond the powers. They took the loan not sanctioned by the articles and the memorandum. And then we have seen a case being taken to Nyarujenje. And of course, the summons are not provided to the Kanban. Then of course, the court makes a determination in the absence, and of course, the Kanban is made to pay hefty. And therefore the question, was the judgment right? And we are saying no, the judgment was not right, because the law under Article 31 provides how the summons are supposed to be provided, and therefore the manner in which this happened was not in accordance to that section of the law, and that's why the judgment is not acceptable. Now, that is that part, and I just want you to take note that if you have been keen to see how information is extracted, then of course that is very clear. Now, of course, I want to a concern that has been raised by one of you: how can the bank sue the directors when the contract was signed between ABC Limited? That's a very good question. How can the bank sue the directors when the contract is between ABC Limited? Now, the answer is simple. The memorandum and the articles, or the memorandum specifically, is a document that is public. Because the loan which was being provided to the company, the bank had a right to ask the directors, as one of the requirements, to produce the memorandum of association. And therefore, once the memorandum of association was provided, and the reasons provided by the directors for taking the loan could have been evident that the company did not have power to engage in a business of mining, and therefore they could have stood guided not to have provided the loan to the directors. And therefore, by the fact now that the company did not have power to do any business related with mining, therefore the conclusion is the mining business is the business of the directors and not the company. And that's why the directors are supposed to be sued by the bank, because they acted outside the powers given to them. And therefore, because the company is not a human being, remember, the company is not the directors. A company is an artificial person, and this person operates through its documents, and the major one being the memorandum of association. So it was incumbent upon the bank to have asked that the directors produce the memorandum of association so that the bank can appreciate that the loan taken is for the purpose that is provided for. But because they did not do so, then of course they did it ignorantly, and therefore the only people that shall be held responsible were the directors. Because, as I've already said, the assumption is clear. They were not taking this loan on behalf of the company, because the company does not have the power to invest in anything else other than farming. And the money taken was for exploration of minerals, which is an object outside the memorandum of association. That is the answer. That is the answer for the one who raised that concern, and indeed, that is it. And therefore, the next part that I just want now to move to, I just want to move you to the next maybe scenario. But of course, still this smaller section, assuming it is part of a bigger question, and of course the question says, according to Article 33 of Law number 007/201 of May of 05 February 2021, governing companies, where the liability of shareholders of private company is limited, the registered name of the company ends with the word limited, or the abbreviation LTD. However, some companies are dispensed of this obligation. I want you to note that we are basically quoting what the law says. The law says that if you are operating as a private limited company, then the word of the company should end with the word limited or an abbreviation for that word Limited. And then, of course, the same law says, however, there are companies that are dispensed. In other words, there are companies that may not necessarily end their name with the word limited, whether in full or in abbreviation. And therefore, the question, explain which kinds of companies are exempted from the above requirements. Explain which kind of companies are exempted from the above requirements. Now, before I handle this, I just also want to make a brief comment on the materials of study. Now, I have realized over time that a majority of the candidates are not even aware that we have a law that is governing companies. And therefore, they read maybe the module provided for by the Institute of Public Accountants of Rwanda alone, and therefore they ignore completely the law. And therefore, I want you to note that the module or the other materials that have been provided, they must go hand in hand with the law. And of course, you are not only limited to this, but you are expected as a person looking forward to be a certified public accountant to have wider knowledge. So reading is not restricted. And therefore, you need to take note of that. And therefore, this other part, for example, when the law is being quoted, you are expected to have understanding, to have knowledge. Because when a law is quoted, you cannot guess. It must be in accordance to the law, because the law, as the one which has provided what is expected of a private limited company, and then of course it provides exemption for the obligation that is imposed. And therefore, if you have already read the law, that's when you can imagine or you can know what are those companies that are exempted from dispensing the word limited, either in full or in abbreviation. And of course, one, we are being told that the board of directors, which is the managing entity of the company, may direct that a company be registered without the abbreviation of that word if, one, a limited company to be formed as an objective of promoting commerce, art, science, religion, charity, or any other useful objective. So we have said, if the company is concerned with aspect of commerce, that is business, art, science, religion, or charity, or any other useful objective, then it may register a company, and necessarily it may not use the word limited. It may not use the word limited. And I want to believe that you understand the rationale. If we pick, for example, the aspect of charity, then you can be able to see that the aspect of liability in terms of shares is not the concern, because the concern is what is the purpose and what is it that this company want to achieve. And of course, if it is doing business, then it is doing business for purposes of promoting the above aspect, which is religion or charity or any other work which is of great importance to the society. And therefore, the members are not concerned more on what they receive, but they are concerned that the business they are doing, if it can be able to cater for the interests of the society, they are good to go. And then number three, and that it does not intend to distribute its dividends to shareholders. That one has already been captured. If in the scenarios provided, the company can be registered without the word limited, because the word limited brings out an aspect where liability at a given point of time shall arise. And of course, the liability shall arise now based on how the shares have been paid. But because the overall aspect or the overall purpose of this company is more to give than investment in terms of where members earn dividends, then of course the law allows them to dispense without the word limited. And therefore, that basically needs you to have knowledge of the law. Then, of course, the last part of that question is, what are the conditions? Give the conditions provided by the law in Rwanda for a name to be reserved or registered by the Registrar General. Now, of course, we have moved from the word the abbreviation limited, and we are saying, and I want to believe that this you have some knowledge, that in order for you to register your company, the first thing is you must go and, of course, search the name. And once you have gotten the name, then you reserve that name. You reserve that name. Now, of course, by reserving the name may not necessarily mean that you have registered, but of course, you reserve the name. And therefore, we are saying, what are the conditions that must be fulfilled, for example, so that you may reach the level where you can now register the company or reserve that name to yourself. And of course, that is the law. The law first says that in order for you to reserve a name, that name should not contravene any law. Should not contravene any law. Now, of course, one could ask, how can a name contravene a law? There are names which are obscene. Obscene names, or names which are not sound. Now, of course, to say a name is not sound, we are basically saying that there are names when you hear, you could not want to hear. So those names contravene the law. That's one. Number two, in order for you to reserve your name for your company, your name may not be misleading. Your name may not be misleading. Now, which name can be misleading? Of course, that's the question. Which name can be misleading? A name can be misleading for example, in Rwanda, we may assume that Primus is known as a beer. Then someone goes and registers his company, and his company Primus is water. Primus is water, but known Primus is a beer. Now the question here is, anyone who could see this Primus water, he will think that it has been manufactured by Pradua, and therefore it is one of its products. And I'm sure you know the campaign that Pradua has made, right? It is a brand name, and therefore people will drink this brand, and the owner will get a lot of money out of what he has not invested. And therefore, that name, as much as it may relate to water, will be considered misleading and therefore cannot be registered. And then, of course, a name cannot be registered or reserved which goes against good morals. Morality is part and parcel of the society, and therefore it is expected that any name given to any business must promote morality and not to the contrary. And therefore, any contrary will make the registrar not to register such a name because it goes contrary to the established norms of morality, and therefore that name will not be reserved nor cannot be answered or cannot be registered as I've already indicated. Now, having said that, I just want, of course, we have said against morality or any name which is identical. That one, of course, is obvious. And of course, if the name is identical and there is another name, notwithstanding any abbreviation that might be there, it may not be accepted. So I just want now to move to the second, maybe to another series of case study. And remember, we are not revising, but we are trying to see, of course, we are basically trying to see how you can extract an information from a case study and use it, and where is the relevant information found. Now, in this case, we have KBC Limited, also a private limited company that is limited by shares of 50,000, to which the value of each share is 1,000. And this company was incorporated in the year 2015. It has 7 shareholders, namely MSA, having 15,000 shares, KNA having 12,000 shares, KZA with 10,000 shares, and KZI with 7,000 shares, IZA with 3,000 shares, and GZA with 2,000 shares. And then, of course, we have INA with 1,000 shares. Now, of course, these are the distribution of the 50,000 shares. 10,000, 12,000, 15,000, 7,000, 3,000, 2,000, 1,000, 50,000. Now, the core business of this company is the provision of telecommunication services. The board of directors has convened a general assembly to discuss the issues arising out of the company, including approval of major transactions that have been put on the table. When the meeting started, the chairperson of the board of directors read the agenda and requested the shareholders to add any item if available. MSA argued that the agenda should be adopted as it is because he knows that it's not possible to add an item in the agenda on the day of the meeting. Now, I want you, if again I could repeat, so that you can be able to pick the issue. Now, remember in my discussion with you earlier, I say that case studies come with a lot of innuendos and a lot of characters, a lot of names. And if you are not keen, they remove you from the focus. And therefore, in simple, when you are reading the case study, basically read it simple as it is. KBC Limited is a private company limited by shares with 50,000 shares with a value of 1,000 per share and incorporated in 2015. It is owned by 7 shareholders, namely MSA with 15,000 shares, KNA with 12,000 shares, KZA with 10,000 shares, KZI with 7,000 shares, IZA with 3,000 shares, GZA with 2,000 shares, and INA with 1,000 shares. Those are the distribution of shares. Is it important? That's the question. The core business of this company is telecommunication services. That's, remember now, if you are reading the parts. The first part is a company is private. The second part, it has 50,000 shares which have been distributed in the manner that I've indicated. The third part, the business is telecommunication. The fourth part, there is an annual general meeting. The fourth part, there is the agenda, because if we read the core business of the telecommunication of the company is telecommunication services. The board of directors has convened a general assembly to discuss the issues arising out of the company, including approval of major transactions put on the table. When the meeting started, the chairperson of the board of directors read the agenda and requested the shareholders, if there is any issue that they have that is of concern, they can add it either to be part of what we call any other business to be discussed at a later stage. Then one of the members, who's MSA, argued that the agenda should be adopted as it is, because it is not possible to add an item on the agenda that has already been shared, and therefore the suggestion by the director is against the law. That is according to the case study. And therefore, what are the issues? And what are we dealing with? We are on meetings. If you want to find where the information is, we are dealing with the meetings of the company. In this meeting, we have the annual general meeting, we have the extraordinary meeting, and of course we have other meetings. And therefore the issue here is meetings. And therefore, if it is meetings, what we are looking into is the manner of conducting meetings. And of course, when we are talking about the manner of conducting meetings, you'll have to agree with me that the procedure provided for when it is a public company, it is not the same as when it is a private company. That distinction, you must have it. But of concern is, once the agenda has been shared, is it possible to include any other matter that was not part of the agenda? And that is what one member says, that no, it is not possible. So that is the issue. The 1,000 shares, the 200 shares, the 3,000 shares is not an issue anywhere. The aspect of KBC being a private company, to some extent, also has no much weight. The issue which has weight here is, does the law allow anything to be discussed which was not part of the agenda? And therefore, when we go to the question is asking, do you think the argument of MSA is true? Explain your position. Now, of course, these are things that are provided by law. And basically, the argument that there is nothing that can be added on the agenda is not true. The position of law is, as long as it is a general meeting of shareholders, a member has a right to propose an item before the meeting is held or at the meeting place before it is adopted by the members. And that's the position, that if there is a matter of concern that could have not been captured by those who drafted the agenda, it does not mean that members who have concern and an issue of concern cannot raise the issue. The law allows that the issue can be raised, be considered, and if the members feel that is of their great interest, they will adopt it and it will be part of the agenda and it shall be discussed, and accordingly the solutions shall be passed on it. Now, where one cannot be allowed to add an item in the agenda is in the extraordinary meeting. And I want you to pick, the word is extraordinary meeting. Now, extraordinary meeting, as you might be aware, for those who are aware, there is no time period I was saying, remember, there is no time frame to hold an extraordinary meeting. This meeting is held when the matter to be discussed cannot wait for the annual general meeting. And if it's such way that waiting can take place, it can be detrimental to the company. For example, all the directors of the company have resigned, and there are 6 months for the annual general meeting to be held. Can the company operate without the directors until the specific time? And the answer is no. And therefore, a meeting shall be scheduled with the purpose only of electing or appointing the new directors. And therefore, in that meeting, and by virtue of its nature, an item may not be added. And that's the position of the law. Then, of course, from the scenario that we have looked into, what are the general rights of the shareholders? What are the general rights of the shareholders? Because do the shareholders have rights in the general meeting? And of course, vis-a-vis the first concern we have raised about the agenda. And yes, the first of that is that on any issue that is brought to them, propose an item or items to be discussed in a meeting, like major transactions that were on the agenda. And therefore, they have a right where they find that they need to raise a concern, and therefore they will raise that concern at an appropriate time, and of course, such part of the discussion. And then to raise agenda or to add an item that becomes part of the agenda. of the meeting, and of course, where, for example, they says of a matter which is beyond the directors, for example, a major transaction. And I want to believe that by this time you understand what is a major transaction. And the position of law is that the directors of the company cannot undertake a business whose value is more than 10% of the total assets of the company, or to dispose any property of the company whose value is more than 10% of the total assets of the company without the consensus of the shareholders. And for that reason, if they seize of the opportunity and find that that is going to happen, then the law provides them a right to raise such an issue and to bring them to the table for discussion and onward approval. And therefore, in addition to this aspect of voting, the shares held by the shareholders confer to them the right to share in the distribution of dividends of the company on the basis of their investment, Then, of course, it also confers them the right to share. I've already said of dividends, but also they have a right to share in the distribution of the surplus or surplus assets in case of liquidation. In other words, assume the company is sound and for reasons better known, the company is put in liquidation. And after having paid all the creditors and there is a surplus, then of course, the shareholders have a right to share these surplus assets in proportion to their investment. In proportion to their investment, not equally. Then, of course, in accordance with the other rights and privileges and subject to such limitations or conditions on such rights as may be provided for in this law, the company's incorporation documents, the right to vote on shareholders' resolution. Of course, we are saying, notwithstanding all those rights that we have already indicated, there are restrictions that have been put in place. And of course, they have, for example, in voting, they can vote to appoint or to remove an auditor or a director of a company. They can vote to approve a major transaction or otherwise. Remember, it is not necessary that it must be approved, but they may also reject. That is also a solution. They may also vote to adopt or to alter the articles of association, which is a company that is being registered. Of course, the articles must be adopted. And if there is a meeting that has made changes to the articles, of course, there must be voting to the effect so that those articles are changed accordingly. Then, they also have a right to vote to dissolve a company. This is what we call voluntary liquidation. And of course, sometimes, if, for example, the company has reached its apex, and of course, there is nothing more to be done, then of course, the shareholders will accordingly, in an assembly, annual general assembly, they can dissolve that now the company be dissolved. Then, of course, if there is a need for amalgamation, that is two companies coming together for a given purpose and a given point of time, then, of course, it requires the members voting to approve this. And therefore, that is a right with regard to voting in which these members will exercise. Now, having said that, I want you to take note, as I've indicated, as we go down, you can see that every case scenario that we are looking into, it raises issues first, And then on the basis of the issues raised, then there are follow-up questions. And I want you to see, for example, the case study that we have here. KZA Limited is a private company limited by shares, which was incorporated in 2015. And of course, with the main activity of exporting minerals in Rwanda. And it has a share capital of 100 million. And its shareholders are namely KSA, MZI, and MTI, in which they have paid all their shares subscribed for in the company. MTI has the special voting rights in all the decisions made by the shareholders. As KZA Limited is in a financial crisis caused by the increase of transport cost due to the absence of petrol at the international market, no hope of paying them. I want you to follow that KZA is a private company limited by shares. It was incorporated in 2015. The major shareholders, of course, it has the capital of 100 million. And of course, we have the shareholders. And therefore, MTI has the special voting rights in all decisions made by the shareholders. Now, KZA is in a financial crisis. And this financial crisis is caused by lack of fuel and the increase of price of fuel at the international market. And therefore, as a result, there is a decrease of the working capital. The debts are increasing, and with no hope of paying such debts. And as a result of the fear that this company may eventually collapse of losing everything, one of its creditors has requested the Director General of Rwanda Land Authority to put caveats on some personal immovable properties of MZI and of one Ms. MTI, because he believes that when the company's assets will be insufficient, those assets can be used to cover the debt. Now, I want you to basically, as a good candidate, the case study should not divert or take away your energy. But instead, as I said, you're supposed to be able to pick the main issues. Because if you are looking into what we are looking into, as far as we have read, we are basically seeing where a company is having a problem. And as a result of the problem, chances is that this company may collapse. So one of the creditors, fearing that they may not get paid, he has gone to the Director General of Rwanda Land Authority. And he has requested that caveats. Now, a caveat, for those who have no idea what is a caveat is a request that is made to, more especially, those that are in control of land in Rwanda, that this land should not be sold without the consultation of those who have put these caveats. And therefore, it is like this person has an obligation. If we sell this land, we the creditors, we will suffer. So the land is marked like it has an encumbrance, it has some debt, so that if it is going to be sold first, the debt must be cleared. That's what we call a caveat in symbol. So now this person went and put a caveat on the properties, not of the company, but on the properties of the members, the shareholders. The shareholders, because they feared that the assets of the company are insufficient, and if the company collapses, the debts may not be paid. So that is the issue is that one. The issue is that one. And when I'm saying the issue is that one, the issue is, although this is a private company, can we be able to say that the property of the company is the property of the members, or the property of the members is the property of the company? Is there a correlation between individual property and the company property? That's the question. Or if the company cannot pay or undertake its obligations, can the members be reliable for the obligations of the company? That is the question. That is the issue. So that's the first issue there. And of course, the question here is, as a legal advisor of the Director General of Rwanda Land Authority, draft a legal opinion on the basis of law number 007/2021 governing companies, if such request can be granted. If such request can be granted. Remember, I've said that the request which is made is that these two people are influential, these two people are rich, they have more property than the company, and if the company is going to collapse, the assets may not be sufficient. So can we be able to be paid by these two people because they have good money? And that is the issue there for the question, can this request be accepted? Now, for the person who has raised a concern concerning when is a major transaction is allowed, I have indicated and I have explained that the directors of the companies have been given power to transact all businesses provided for in the articles of association and the memorandum, but anything that will require the use or dispose of more than 10% of the property, then the directors do not have the powers. The directors do not have the powers by themselves to undertake this. And therefore, at what point of time can a company engage in a major transaction? I've indicated that in order for this major transaction to take place, the directors must call for a meeting. And basically, this is not an emergency. There must be an annual general meeting. And in this annual general meeting, then they will be able to say there is a property of the company that is not beneficial and is just death, or it is not profitable. And we want to sell part of this so that we can invest this money for the betterness of the company. And when members consider, discuss, and agree and vote, then they give the directors the power now to undertake that transaction. Equally, if there is a new machinery or new machines that the company wants to purchase, and the value of such machines is more than 10% of the total assets of the company, then again, the directors do not have power on their own to go ahead and purchase these machines. They must come to the owners who are the shareholders in a meeting and bring this issue and explain that they desire, and they have formed an opinion that if they purchase these machines, the company is going to make double the profit, and therefore it will be good for the company, and therefore it shall be discussed. And when it is approved, a resolution is passed, and in that way now the directors are given the power to enter into major transaction. And that is the response. And that is the response to that concern of one of you who has raised that concern. And therefore, that being the issue, I want to just move. I want to move to the concern that we are dealing with, because I've already said that here are some members who are concerned that the company's assets may not be sufficient, and they have approached the Director General of Rwanda Land Authority, and they want the lands of 2 members to be caveated. In other words, they are requesting that you see these lands may be put on a rat, that they should not be sold, so that in case the company collapses, the creditors can rely on this. And therefore the question is, as someone with knowledge of company law, do you think this request can be accepted? And of course, you could be having the answer in your mind. And of course, the answer, of course, in affirmation, and the answer with justification. Because one, we can be able to say no, because a company is separate from the members. There is separation. A company and members are not one and the same, because we know that a company is a legal person. From the point that the company is registered, it ceases to be one and the same with the members. And therefore, the property of the company is not the property of the members. And therefore, in no way can the members' property be of concern to the company, because the company operates independent of its members. And therefore, if you look into the opinion or the request, it is very clear that, of course, the law allows caveats to be put. The law allows, if someone owes you your money and he has property and they want to sell it, someone can go and put this caveat that before this land is sold, this money that this person owes me must be paid. And that is allowed. But what is the position with regard to the 2 members? The request to put caveats on some personal removal of property of MZA and MTI cannot be granted because their liabilities are limited to the shares subscribed. And we have seen that all the shares are paid for. And therefore, not only that they could have been paid for, there is no way that this could have been put. But of course, in case they had taken shares and part of that shares have not been paid, of course, the creditors could have had a right to put caveat because their shares have not been paid. And if the company collapses, it may be difficult for them to pay up. And for that caveat can act as a break for them to dispose such land to the at the expense of the company. Now, again, take note that the liability of shareholder to the company of a company's obligation is limited. Of course, any amount unpaid on a share held by the shareholder, and any liability expressly provided for in the company incorporation document, which may provide that the shareholder's liabilities are unlimited. And therefore, we are basically saying that in this case, as far as these members are concerned, they have made good their liability for their shares are fully paid, and there is no other obligation undertaken by them which can be the basis upon which a caveat can be taken. Now, the next question is, assume that MTI supported the resolution which caused KZA Limited to fall into loss. Do you believe that she can be reliable in respect of the exercise of such right of faults? Remember, we are saying MTI has more powers of faulting, and therefore we are basically saying exercising his right to fault, and he faulted for a resolution of his effects is to bring this company down. Can MTI be responsible for the right he exercised in voting in the meeting? And therefore, the question is, the answer must be either one, no, or yes, and then, of course, the justification. We are saying no. He cannot be held reliable, whatever decision he takes, because the decision is not a one-person decision, but it is a common resolution. And therefore, we are saying MTI cannot be reliable for the resolution taken by KZA Limited, having fallen into loss because a shareholder voting solely on his or her capacity as a shareholder in the exercise of any of the powers does not owe any duty to the company or to any other person, and does not incur any liability in respect of the exercise of or failure to exercise votes to which that shareholder is entitled. The power through which a shareholder can exercise his right is not reliable, and are those related. Where it can be made reliable is where he authorized an allotment of shares, authorized the alteration of the shareholder's rights, authorized the appointment or the removal of a director. We are basically that the power through which a shareholder can exercise and she is not reliable are those that are related, for example, if he votes to authorize the allotment of shares, he votes to authorize the alteration of shareholders' rights, he votes to authorize the appointment or the removal of a director, he votes to authorize the appointment or the removal of an auditor, authorize any alteration in the company incorporation documents, or authorize a major transaction as provided for under Article 197 of the law. We basically all apply for a solvent company to be removed from the register. These are areas in which any shareholder cannot be held responsible, because this is a right protected, and there is no action that can be taken against such a member per se. And therefore, we have answered the first, that no, the person in exercising his right to vote as an individual, he cannot be held responsible for the consequences that shall come out as a result of such a vote. And then, of course, the question that follows is, discuss how shareholders can exercise powers by resolution. Exercise how shareholders can exercise powers. Remember, we have talked about the powers to vote, but now the question is how. And the how, basically, we find that these are the ways through which shareholders can exercise powers by resolution, not regulation as such. Number one, they have powers to exercise during the annual general meeting. And the annual general meeting, as we are all aware, this is a meeting that must take place, annually. And for those that have read, you know that the law provides annual to mean 12 months, 15 months, and 18 months. I do not want to explain that one, but for those who have an idea, when we talk about the annual general meeting, we have three aspects of it. For a new company, the law says that it must be able to hold their meeting not beyond 18 months. So 6 months you are seeing here is the last preceding meeting not later than 6 months. If there was a meeting after 12 months, another year the meeting should not go beyond 6 more months. In other words, that is 18 months. So we have 15, we have 12, we have 18, and that one all is considered a year. And therefore, within this meeting, for which I would want to imagine that you shall also be able to know what are the issues that the members exercise these powers on. One, and again, these aspects that we are looking in which members exercise their power, I want you to know that they form part of the business of the annual general meeting. Such a business is the consideration and approval of the financial statement. At that meeting, they receive the auditor's report, they consider the annual reports. Then it is in this meeting that they appoint through resolution and of the directors through resolution, they appoint the auditors through resolution as they may deem necessary. Of course, they act on a number of issues, other issues as may be deemed necessary by the annual meeting. And therefore, those are the powers now which the shareholders exercise. Of course, at a shareholders extraordinary, that is in the annual extraordinary general meeting, of course, a special meeting of shareholders entitled to vote on an issue, but before it is called by the board of directors or a person who's authorized by the Constitution to call the meeting. That is the extraordinary meeting. The extraordinary meeting is called by the board of directors upon the request by written notice served on the company, signed by one or more than persons holding the right to exercise not less than 5% of the votes entitled to be cast on the issues to be discussed. In other words, there must be a meeting called by the board of directors, but with the support of 5% of those who may vote on these resolutions. Of course, then we have an extraordinary meeting can also be called by the shareholders' written resolution in view of a general meeting. If there is a need and the shareholders feel that they cannot wait until the end of the year, then of course they have a right to hold this, the extraordinary meeting. And of course, in order for that to be done, there must be a resolution in writing signed by shareholders, which is valid, and if it has been passed at the meeting of those shareholders where the resolution is signed by the shareholders, they are entitled to vote on that resolution at the meeting of shareholders and hold not less than 75% of the votes. And of course, these are when it comes to an extraordinary meeting, an issue which cannot wait until the end. And of course, they also, remember, we have said they have what we call ordinary voting. We have what special voting requires 75%, and we have what unanimous. Unanimous basically means a resolution passed by the majority of the shareholders. So that is a manner in which the powers of these shareholders are exercised, or how the powers are exercised. Now, allow me now. Yes, I'm looking at the concern about this month. I said the position of law with regard to annual general meeting, and it gives 3 prepositions. The first preposition is symbol that for a newly formed company, because of a number of issues, it has not started, it's mixed up, and it has issues. The law says that in their first meeting, they should not go beyond 18 months. I want you to get the position. Is these are for the first newly formed company. And we are not saying that the newly formed company cannot hold its annual general meeting within 12 months. If it is organized well, it can hold its meeting in 12 months, which is a year. But if there are teething problems which cannot allow that to happen, then the law provides that they should not go beyond 18 months. They should not go beyond 18 months. That's the first position. Then the second position, the same company in the succeeding year, it is supposed to hold either a meeting after 12 months, which we call annual, and if again for reasons beyond them, it is unable, then the law says such meeting must be held within 15 months. It must be held within 15 months. And therefore, the two are exceptions. And I've explained the exceptions clearly. The norm is 12. And that's why we have 3 positions: 12, 15, and 18. Under normal circumstances, you have any teething problems, you must hold an annual general meeting at the end of each year. That's why we call it annual. And annual, it has 12 months. But for a beginner, a new company that has been formed, having issues here and there, and they are trying to run up and down and things are not working, then they are told they must be able to convene the annual general meeting not later than 6 months after the calendar year. And you add 6 to 12, it gives us 18 months. And then in the succeeding year, the law says such a company that held its annual general meeting at the 18 months, in the next coming year, it is either they shall hold the annual general meeting exactly at 12 months, and if it is not possible, they should not exceed 15 months. That's the position. And take that position, and it is an overall and a simple position, not complicated. So when you see all those explanations, that is what it basically means. And I just want you to get it clear and you get it right. You get it clear and you get it right. And therefore, allow me to move you to maybe another scenario. And if time will allow us, and if the hosts allow us, then maybe the 1 hour from 4, we may take it to interact. We may take it for interaction so that I can hear the concerns you have. And then, of course, we can try to see whether we can handle such concerns if time allows. But allow me now to take you through this scenario. In a general assembly of the shareholders of the company, you said A Limited, a discussion was held to collect views on the issue of removing a company from the register of companies as one of the resolutions of not getting into a huge loss. I pause and go back. In a general assembly of the shareholders of the company is USAID A Limited, a discussion was held to collect views on the issue of removing a company from the register of companies. That is the issue. Removing a company from the register of companies. And the reason was simply, if it is not done, the company was getting into a huge loss. One member, Unya, argued that really the General Assembly can take a resolution of requesting the Registrar General to remove the company from the register of companies. After a long discussion, the General Assembly adopted the resolution that the company should be removed from the register of companies within the procedures provided for by the law, and nominated a team to work on it, and was requested to submit a proposal in 5 working days. Now remember, the issue is removal of a company from the register of companies. And therefore, as a good student, you could now be equipped with information on the grounds upon which a company can be removed from the register of companies, and who can remove a company from the register of companies. That is the basic information that you could have been having now before you look into the question. And then, of course, the question now, you have been approached to help the team for analyzing and proposing the procedures through which USAID A Limited can be removed from the register of companies. Discuss the grounds for removal of a company from the register of companies, and advise the company which one can be used to request it. Now, remember, the basis of the information which is critical is that the company is making losses. And the only way they can stop this company from continuing to make losses, they feel, is like to ask that this company be removed from the register so that it goes for a whole day, in order for the company to think on how they can be able to work things out. And it was agreed that it is normal that once the company has passed the resolution, that resolution can become the basis of this company being removed from the register. Now, of course, subject to this resolution, a team was formed. And the purpose of this team was to work out a proposal which, when taken to the office of the Registrar General, shall be convincing, and upon which he can only remove this company from the register. Now, having raised that concern, that you must be able to know the grounds upon which a company can be removed from the register, because that is knowledge that is available. And who can, and in the word who can, we are basically saying, can the company itself, because when we are talking about a resolution, that resolution is a company. Can the company itself ask that it be removed from the register of companies? So now, taking that in mind, then our concern now is to look onto the grounds. The grounds upon which a company can be removed from the register of companies. Remember, I had asked the question, who can remove? And the first is that the Registrar General is a one who can remove a company from the register. Under what grounds? One, if the company is an amalgamating company other than an amalgamated company, and on the same day, the Registrar General issue a certificate of amalgamation. Now, I want you to take note, and I also believe that those three words used in the same sentence may bring you confusion, because it is saying if the company is an amalgamating company other than an amalgamated company, and on the same day the Registrar General issues a certificate of amalgamation. Now, what does that statement basically say? The statement is basically saying that if there is an amalgamation, amalgamation basically means that there are two companies that may be doing similar business, but as they do their business, they do it at disadvantage. Either they do not have enough resources or capacity. And there is a feeling that if they have a synergy, they're coming together, then their capacity or their resources shall be more sufficient. So now the amalgamating company is that company that has approached another one. For example, we have company A and we have company B. Company A approaches company B. Now company A becomes an amalgamating company, and company B becomes an amalgamated company. Now, the consequence of amalgamation is that one company, that is the amalgamated, goes silent. And of course, for good of a number of you, you must by now be very clear in your mind about the difference between amalgamation and merger, because they are two very closely related but quite different. In an amalgamation, the amalgamated company does not disappear. It only goes in mole bond. It goes in mole bond. And therefore, the issue is that we have an amalgamating company, and of course, there might also be an agreement that the consequence of amalgamation may lead to a new, completely new company. That is A, B, and C. A being, we can now call A an amalgamated company, B an amalgamated company, and C an amalgamating company, because it has now the two. But equally, as I've indicated, A may decide now to retain its name, and then only B enters into it and P disappears. And therefore, we are basically saying, if on this process having taken place, and the registrar has been informed, and he has issued a certificate of amalgamation, the registrar has issued a certificate of amalgamation, then we can say now company B, in this case, can be removed from the register. And if there was C, then we are basically saying company A and B will be removed from the register. The issue is very clear. A certificate of amalgamation has been given. And of course, among the things that is provided for this certificate is the duration upon which the amalgamation is taking place. If the amalgamation is for 2 years, then of course these two companies, A and B, shall be removed from the register for the period of 2 years. And after the lapse of 2 years, the two companies can still now return back to the register in their respective names, and of course, the amalgamating one can be removed at that point of time, and the certificate of the other companies as they were will continue to work. That's the first condition. The second, if the Registrar General is satisfied that one, the company has ceased to carry on business and there is no proper reason for the company to continue in existence. That's the second. And of course, we are basically saying that on coming out with a proposal, it must conform to these requirements, that indeed the company in question that we are dealing with has ceased to carry on business and there's no proper reason for the company to continue in existence. The number three, the company can be removed from the register by the registrar if such a company has failed to pay fees due to the registrar under the law. There is the fees that is paid, for example, for the registration. If they fail to pay, then of course the registrar has a right to remove such a company from the register. Then number four, if the company has not filed its annual return as required under this law. The law requires that annually the company must be able to file its annual returns. And if the company has failed to do so within a period of 18 months, then the registrar has a right to strike off this company's name from the register. Then number five, if the Registrar General receives a request in a form approved by him or her from a shareholder authorized to make the request by a special resolution of shareholders entitled to vote and voting on the question. Now, this is a ground that I just want you to look into. If the registrar received a request in a form approved by him, in other words, that there must be a request that is made to the office of the registrar, upon which he issued a form which has to be filled by a shareholder that is authorized by a special resolution of the shareholders entitled to vote and voting on the question. And therefore, if there is this resolution and entered in a format that is given, then that can be a ground for the removal of a company from the register of companies. And six, if the board or any other person, where the incorporation documents, that is the memorandum of association and the articles of association of the company so requires or permits that the company be removed from the register on the grounds, one, set out in paragraph 2 of the law. In other words, there is grounds in which, for example, the articles provide that if there is disagreement, that the membership of the company is divided in the middle, and there can be no way for any resolution or for any business to be undertaken, then such a situation can arise and can lead to the removal of the company from the register. Then if that can be proved, then of course, as provided by this, and of course, the information or the application is delivered to the Registrar General, then he can act on it. Or number 7, if there is delivered to the Registrar General an application for removal of an insolvent company from the register, and no liquidator is acting in relation to that company, or the liquidator appointed fails to deliver to the Registrar General the documents required to be filled under the law relating to insolvency. Now, in a nutshell, we are basically saying that if there is a company that is insolvent and it may not have problem of liquidation, or in other words, there are no people who are crying, then of course, upon the application, the registrar can remove that company from the register. And finally, if a liquidator delivers to the Registrar General the final report and the final accounts of the quotation and the statement are required by the law governing insolvency. If the exercise of liquidation has been done, the debts have been paid, the outstanding surplus has been shared, and the report gives a clearance, then of course this company can be removed from the register. And therefore, what will be required is that a proper and approved resolution that is a special approved resolution is what can be required to be submitted in order for this company to be considered if it can be removed from the register of companies. So that is the information that is available, and therefore that one you need to take into account. And then of course we are saying, is it enough that the issue was discussed in a General Assembly and the chairperson of the board of directors can base on it for requesting for removal or not? And of course the question we are basically saying, there was a discussion, and in the discussion what we saw is that the company was going to make a loss, and therefore the resolution was passed. The question we're asking, is that enough? And the answer is no. The resolution must capture the aspects that have been raised above. And if it is because the company is going to make a loss, that's not a reason, because it's upon the company to have proper strategies in place and to work for the very interest for which it was formed. And therefore, by the basis that the company is going to make laws, that is no ground at all. And that's why we are saying no, it's not enough that the issue was discussed in General Assembly is the basis of requesting for removal, because to request it, it is required that the Registrar General receives a request in a form approved by him. And such form, you can see it is not there, from shareholder authorized to make the request by special resolution of the shareholders entitled to voting on the question. And therefore, just discussing cannot be the basis. And of course, once that is done, when the Registrar General has started to analyze the request for removal of a company from the register of companies, he has received an objection from a creditor. When, of course, we are saying it has gone he has gotten an objection from a creditor, A, B, informing him not to remove it as long it has not yet cleared the debt. Now, the next question is, after listing the duties of the Registrar General, where objection is received, what could you do as the Registrar General? Now, of course, when we are saying after listing the duties, we are basically saying what are the duties of the Registrar General vis-a-vis the removal of the company from the register of companies. And we are basically saying that there is an approved resolution, special resolution, that has gone to the office of the registrar. But one creditor whose ABA has gone and raised an objection as to the removal of this company from the register on the basis that his debt has not been cleared. And therefore, the question is, now you are supposed to list the duties of the registrar and then explain on the basis of the objection, what can the registrar do? And of course, the duties of the Registrar General where objection is received. Now, when there is an objection to the removal of a company from the register on the ground that the company is still carrying on business, or the company is part to a legal proceeding in court, and that the company is in receivership, or the company is in liquidation, or both, the Registrar General does not proceed with the removal unless the Registrar General is satisfied. We are basically answering the first, that if an objection is raised concerning the removal of a company from the register of companies, it is important that the Registrar General must ascertain whether that company is still on business. Number two, whether there is a case in court that is ongoing. Number three, whether that company has been put in receivership and there is somebody who's trying to work around it to bring it back, or the company is in liquidation, or both. Both, that is, there is someone trying to turn things around, and still there is a process of liquidation that is going on. And of course, the registrar is asked not to proceed to remove this company from the register on the basis of the almost 4 grounds that have been provided. However, if the registrar is satisfied that the objection has been withdrawn, in other words, there is a person who raised the objection and later found that it is against his interest and he removed that objection, or number two, any facts on which the objection is based are no longer correct. In other words, the information upon which the objection is based is not correct, and therefore there is an error in the objection. Or number three, the objection is frivolous or vexatious. In other words, the objection has got no legal ground. And to that effect, the law says, where an objection to the removal of a company from the register is made on the ground that's specified in items number 4, number 5, and number 6 of Article 281 of the law governing companies, the Registrar General stops the removal process and requests the person objecting to serve on the Registrar General in a period not exceeding 30 days to provide his or a notice of application to the court for an order. In other words, after the registrar stops, then the person objecting must also, within a period of 30 days, seek the order of the court to legalize the whole process of stopping the process, and that the company be put into liquidation if it has not been put, and that the company not be removed from the register. And for this case, the Registrar General could stop the procedures for the removal and wait for the objection to be withdrawn, or be sure that the debt is paid. Now, the third and maybe final issue on that question, in the inspection ordered by the Registrar General, it was found out that there are some offenses that might have been committed by the Board of Directors and the shareholders of UZA Limited when it was in the process of removing the company from the register of companies. The Registrar General found out that one of the shareholders disclosed false information on beneficial ownership, and immediately he reported to Rwanda Investigation Bureau for investigation. Then the question, what should be the offense the suspect might have committed? And upon conviction, what is the criminal sanction that is provided for such offense? Remember, the issue here is false information was provided, and therefore the offense is disclosing false information on shares or providing false information. And if this person be convicted, he or she shall be liable to imprisonment for a term not less than 1 year and not exceeding 2 years, and a fine of not less than 5 million francs, but not exceeding then 10 million francs. That is the offense. Now, to that end, and it is now 4:20 approaching, I do not know whether we have now room how do I get, I don't know whether we can get room to hear from you, because I say that if we can interact for the few minutes, it could have been better, but I don't know whether that permission has been granted. I can see that still I have not seen the response. Now, for those who can still ask questions through the chat, I think I can be okay to deal with it, and it will be okay. So if you have anything concern, please you can raise it so that I can deal with it. Maybe as I continue with maybe another case study, and therefore, if you find that to be okay, I'm in touch with the chat. I can see the questions and I can deal with it. So feel free. If there is anything that you feel of concern where you are reading and you do not get, I have no issue. I will deal with it, and I will be able to use this opportunity as a way of interaction, because as I said, I'm just a panelist and I do not have the powers to give room for participation, as that power is with the host. And therefore, as I wait for questions that you may raise, I want to maybe continue. I will display to you another case scenario, and we try to go through as I wait for any question that will just arise. Now, in the next, I want you to note that CDA is a public company limited by shares and owned by 5 shareholders with different classes of shares. Its registered office is based in Uye district with different branches in all districts. As required by law regulating companies, all records are kept at the registered office. However, due to the issue of space for keeping the Kanban document at the registered office, the issue was discussed in the meeting of the board of directors for taking a resolution. Some directors suggested that all records of at least 5 years should be destroyed as long as different regulatory institutions have audited them. Others said that rather than destroying them, they might be kept in its branch located in Ruamagana district where there is enough space. Now, in this short scenario, we are dealing with Kanban records. The issue is about Kanban records. The second issue is where are the Kanban documents supposed to be kept? The third issue, for how long can the Kanban documents be kept in its head office? So those are the 3 questions or the 3 issues that are emerging when you read this case study. The first thing that comes out is Kanban records. And then that is the office where they're supposed to be. It is its registered office. And the registered office, if the company has several offices, we are talking about the headquarters. And then we are basically seeing that there is lack of space. And in the discussion, there is a discussion that the records be destroyed, those that are beyond 5 years, or these records be moved to the branch that is located in Ruamagana. And that's why I've said the issues arising is where are supposed to be the records of the Kanban be kept? For how long are the documents supposed to be kept? Can the documents of the Kanban be kept in the branch office? Therefore, those are the issues. And when those are the issues, when you go to the question, now you confirm whether that what we have identified were the issue or not. So the question is, you are required to decide which one could be adopted between destroying them and change the place where the records are kept. And then you are supposed to support your answer. Now, remember the question is it supposed to be destroyed or supposed to be moved to the branch? And of course, the best option is to choose to change the place where the records are kept. And we find That one, the support is in Article 111 of Law number 2007. And of course, it provides that the principle is to keep records at the registrar office, with the exception that where the company changes the place at which its records are kept, it must within 15 days of such a change notify the registrar general. I want you to note that the position of law is very clear. All company records are supposed to be kept in the registrar office. And I want to repeat, the registrar office is normally the headquarters. However, either due to a space problem, as I've indicated, as it has been indicated, then there is room to move these records. Now, the law does not say that you move them to the branch, but if you are moving them within the 15 days of such a move, the office of the registrar general must be notified the place where these documents have been moved to. And for that reason, therefore, you cannot destroy the records, for the law says that the records are kept for a period of 10 years. The records are kept for a period of 10 years. And therefore, destroying documents which are 5 years old is a contravention of the law, and the law does not allow. Then the follow-up question is, list at least 5 records that should be kept at the registrar office and the time frame of keeping them. Now, of course, you are being asked which are these records that are kept in the registrar office in the headquarters, and within which time frame should be they kept. And these are the following documents that are kept in the headquarters or in the registrar office. The incorporation documents. When you see this word incorporation documents, in your mind, you must be able to take note that we are talking about the memorandum of association and the articles of association. Number 2, the share register, a register that shows the shareholders vis-a-vis the proportion of the shares held by them. The index of shareholders. The index of shareholders is a document that shows how the shareholders have come in and moved out, because the shareholders come and the shareholders go out. And therefore, this is a document which is indexed in terms of those who come and those who go out. Then number 3, it is the accounting records. All the accounting records of the company, they are kept in its registered office. Then we have the interest, a register of interest of directors. And the register of the interest of directors is nothing other than that register which shows how much each director has in terms of the shares. And I am sure you know that the register, the directors take a huge part of the shareholding so that they can be responsible. So that is the interest. This register must be there to show the interest of each of the directors. Then we have the register of minutes of all general meetings and the resolution of shareholders for at least the last 10 years. The last 10 years. Then minutes of all meetings and the resolutions of directors. Remember, the above meeting is for the shareholders. resolutions of the shareholders, and then minutes of all meetings and the resolutions of the directors and of the board committees for at least 10 years. For at least 10 years. Then certificates given by directors under the law at least for the last 10 years. Then copies of all annual accounts, auditors and directors' reports in relation to the last 10 completed accounting periods of the company. Then we have the register of beneficial ownership for at least the previous 10 years. And then finally, copies of all written communication to all shareholders or the holders of the same class of shares during the last 7 years, including annual reports. So if you are keen, you have seen that the documents of the company cannot be destroyed if they are not beyond 10 years. So that's the period. Now, I go to the questions that have been brought, and I start with the first. What is the meaning and the role of the statement in view of a prospectus? What is the meaning and the role of a statement in view of a prospectus? Now, of course, in a company, there are two ways through which a person can become a member. One, the circulation of a prospectus in its manifestation, and I do not want to go to the manifestation of a prospectus, but I just want you to know that the prospectus is a document that is issued to the public containing information such as is convincing for the person who receives it to make a decision either to invest, that is to buy shares, or not to buy shares. And therefore, this document is circulated. It can be put on a newspaper. It can be posted on a road. It can be sent on email. And I want you to go and see the information. It must contain information such that information can persuade you to think if you can invest or you cannot. And therefore, that's what we call a prospectus. Now then, one could ask, on the other side, what is a statement in view of a prospectus? Now, to the contrary, a statement in view of a prospectus is an information that is provided to a person who, without the prospectus, has already purchased the shares. Has already purchased the shares. I want you to get that clear. And of course, one could ask the question, how can you purchase the shares and there was no prospectus? And a prospectus is a document. Now, assume I'm involved in a company and we have formed a company. It is registered. We have not issued a prospectus, but I come to you in the word of mouth and I tell you, my friend, there is this company that has been formed. It is very good. It is nice. It has this capital, the capital to start with, and it is good. It has branches all. And I provide you all information. And by providing you the information, you are convinced and you go to buy the shares. The question I ask, is the words of my mouth a document? The answer is no. The words of my mouth is not a document. And therefore, we cannot say that you received a prospectus. We cannot say that you received a prospectus. But I just want you to know that you see, you have gone to buy the shares from a company and you had not received information, that is a document. And then now, I've told you by word of mouth, and you take up the shares. And later, maybe you find, for reasons that are beyond, the company is not performing well, and maybe it is going to collapse. Because remember, business is about profit and business is about loss. Now, you turn around and you say, actually, I took these shares ignorantly and I did not know what was happening because I did not have a prospectus. And indeed, if you go to court, the court will accept that without a prospectus, it could have been very difficult for you to make a decision as to how or on buying the shares. And now, therefore, because there are other ways in which people can learn about the information about the company, now when you go to the company and you demonstrate understanding about this company and you want to take shares, now you are given a statement, a written statement, now a document containing all the information of this company that you had by word of mouth. Now it is condensed into writing and you are given to sign, so that when you take these shares at a later stage, you cannot come and say that you took the shares without a prospectus. And therefore, the role, the purpose of this statement in lieu of a prospectus is to ensure that a person who received information in a word of mouth will not turn and say he had not received a prospectus and therefore he did not know about this company and he invested blindly and therefore he wants to be returned his money. But because now he was given this document, remember, we are talking about a prospectus coming before in inscription. But when we are talking about a statement in lieu of a prospectus, when you have already been allotted the shares, when you have been already allotted the shares. And therefore, if you have been allotted the shares, the issue is you received the information. And on the basis of that information, you went and applied for the shares that has been allotted. But before you are given these shares, then you are made to sign this statement in lieu of a prospectus as a proof that what you are told by word of mouth or otherwise is true, and you signed knowing. And therefore, at no later stage can one decide to jump. That is the meaning and the role of a statement in lieu of a prospectus. I'm sure I have tried to make myself clear. I've said this document is issued after allotment, but before payment. After allotment, but before payment. And the other one is issued even before allotment of the share, before even subscription. Subscription is before you apply for the shares. You are given a document and you are given information. You go to the information which is contained, and you'll find that both information in a prospectus, in a statement of a prospectus, are almost the same. They disclose the true position of the company. Now, that being the case, allow me maybe to look on to the next question. Yes, I hope I've not maybe escaped a question, but I just want maybe to deal with the issue of the difference between a fixed charge and a floating charge. Now, in aspect of security, I just want you to get to note that a floating charge or a fixed charge is used in relation to a security. And in many times, you find that, assume, for example, you are advancing a loan to a company. You are advancing a loan to a company. And as in respect of the loan, you are given a debenture. You are given a debenture. Now, it is upon you to decide on how to provide this loan. The bank may be in need of 15 million, and therefore you just say, I give 10 or I give 5. And therefore you give 5 and you are given a document which is an indicator of the loan that you have paid or the loan you have given. Now, what happens is that in case this company becomes bankrupt, in case this company becomes bankrupt, you shall be considered as a creditor. You shall be considered as a creditor, like any other creditor. And therefore, your charge is called floating. The word floating is basically the basic floating in which something floats, more especially on water, or something floating on the sky. Now, what does that mean? It basically means that you cannot pinpoint to a company a specific asset that you can be able to pick that can cover for the loan you gave. But now you shall be considered as any unsecured creditor. And therefore, after the assets of the company shall be sold, the distribution shall be made in accordance to the amount owed and the amount available. And therefore, we just say that your money which you gave is floating over all the assets of the company that be available. That's one part. The second part, which is now a fixed charge, it is where the company says, we want someone to give us a loan. And then someone comes and says, I'm giving you 15 million, but I want you to show me one of the assets of this company, that if this company faces a problem, this asset is the one which I'm going to sell and I will be able to raise my money. And then maybe the company has a number of buildings. Then you are shown one building, and that one building, if it has a name, then in your document, that is a debenture, you are being told that in case the company has a problem, you have been given building XYZ, that is the one out of which you can get your money from in case there is a problem, there is a financial problem. And therefore now, because your loan now is based on the actual security that you have been given, we call such a security. It creates a fixed charge and it brings you to be called a secured creditor. You become a secure, because there is unsecured creditor having a floating charge, and we have a secured creditor having a fixed charge. And that is the difference. In other words, when you are giving your loan, you have made it very clear that you want to be shown an asset upon which, in case the company has a financial problem, where you can recover your money from. And the company has allocated you a fixed asset. And therefore, when there is a problem, that fixed asset belongs to you. Our other product or other assets can be sold except that one which is fixed for you to recover your money, and therefore that makes you a secured creditor. I want to believe that I've made that one also clear. Now, 1 minute as I check, I should not be able to jump. Any question? Good. Yes, there is one who has made a comment, and I just want to emphasize. I think that the documents must be kept in the register office only. Yes, they are supposed to be kept in the register office only, but we said in a situation where, for reasons beyond, there is a change of the place where these documents are kept, then that change must be informed to the office of the registrar within 15 days. The norm is it is kept in the registrar office, not in the branch. I've just said that maybe because of the problem of space, and maybe good offices are being constructed, then of course we have said during that time, the office of the registrar general must be notified that these documents have been moved to this place for a period of time, and therefore the registrar is aware of such a movement. Good. Now, there is another person who has asked, how is a Kanban a contract? How is a Kanban a contract? And of course, I want you to know that the first basic of how a Kanban is a contract is that you need to take into account, of course, the definition of a Kanban, that it's an association of individuals who come together contributing both material and non-material, and then of course the common objective being profit maximization. Now, from that definition, we are basically saying that there is a people here who come together. Now, the beginning of these people is that the people who come together to form a Kanban, number one, must all have capacity. Must all have capacity. Now, capacity means ability to comprehend. Ability to comprehend. And therefore, it goes all the way as to all of those other requirements of a contract as provided for under introduction to law. Now, in addition, I want you to know that that's why minors cannot be shareholders. I want to believe that you know that minors cannot be shareholders, or people of unsound mind cannot be shareholders. And therefore, that's the position. But I want you to know that more about how a company is a contract is now on the three aspects, which I may not want maybe to discuss further, but I just want to refer to you. One is vocation to share profits. That you have come together, yes, you have the requisite requirements in terms of capacity, offer, consideration, and all of those. But in addition, there is one thing that has brought you together. Both of you are looking forward to share profits. And it is on that part of the sharing profits that you must have shares. You must have shares. Whether that share is one or is many, that is the basis upon which the sharing is based. The second one, and because of time, is the aspect to cooperate. The aspect to cooperate. Because both of you are concerned to the aspect of profit maximization, therefore, you must all be seen to work as a team in order to achieve the objective. And therefore, you cannot imagine where you have formed a company which is making and selling milk, then you find one of your members going outside and telling people that the milk is not good. And through a lot of effort, the little that you are able to sell, that this person can come and sit and share the profit. I want you to believe that, I want to believe that you understand how hard and how difficult it can be. And therefore, if the person is not working for the common good, then of course you are not in a contract with that person. And if you have proof that he goes saying that the milk is not good, that person is not supposed to share in the profit. And therefore, I want you to see those three aspects are the basis upon which the company is a contract, other than the very basic requirements of the contract as provided for under the law of contracts. Then allow me now Now, there is someone who asked a question about a dummy contract, a dummy company, and what is the role of a dummy company. Now, of course, under the law that we are guided by, that is the law of companies in Rwanda, I want to believe that the law of a dummy company, the law does not allow a dummy company in Rwanda. But these dummy companies are there in other places, and the manner in which they have been registered in those countries is maybe basically if they are set as conduits for purposes that maybe might be to recover or to get some information, that's when they are being registered. But I do not see where in the law in Rwanda allows for a company, a dummy company. A dummy basically is just a company that exists on paper, but on the real sense, it is not there. Now, sometimes if, for example, for purposes of getting to information, someone may just have that company and allow that person maybe to go through and be able to see other similar companies that might be in place and what they are doing. And that one may be a cover basically to get in and see many things, but it is not provided for under the law governing companies in Rwanda, unless maybe I'm not informed, but I'm very informed. Yes, I can see there is someone who said that if in the case of the company I talked, which the director of Rwanda Land Authority was asked to provide for caveats, and then one has said that if the company was not a company limited by a company limited, then of course it was okay that a caveat be provided. Now, I want to believe by the fact that a company is registered, as I did indicate, the first consequence of the registration of a company is that the moment it is registered, from the very point that the company is registered, whether it is private or public, the first consequence is that the company becomes a legal entity. That's the beginning point. In order for you to understand why, remember the company we were dealing with is private. And private does not make the members and the company one. The moment the company is formed, it is a matter of fact that from the registration, from that moment of registration, it becomes a legal entity. Now, what does the term legal entity mean? It basically means that from the very point of time that the company is registered, it becomes in existence in the same manner like another human being who's a bearer of rights. Some of those rights will include ownership of property and the sale of that property. And therefore, when the company now is being formed, it basically becomes an independent legal person apart from the shareholders who constitutes it. And therefore, the implication is that there is a company on one side and there are parties on the other side who are members. And therefore, you've come together, you formed a body, which is an artificial body, that is going to undertake the business on your behalf on the basis of the knowledge of the board of directors. And therefore, when this company is acting, yes, we agree that it is acting on behalf of the shareholders. But then, can each action of the company make the shareholder to be reliable? The answer is no. And then again, if the aspects of reliability, remember we said the company, the aspect of reliability does not really need to come out that the company must be limited by liability, and then we say no. The moment the company is formed, by the fact that it's formed, whether it is, unless it is a company with unlimited liability, but the company that we are talking about where Caveat Ping was being asked was a company limited by shares. And therefore, the aspect of the person being taken or a creditor going to ask that a caveat be provided for the land belonging to a shareholder does not hold water, because the shareholder is not the company and the company is not a shareholder. That is a point that must be made clear. And for that reason, therefore, if the property could have been the property of the company, then the creditor was right to go and ask for a caveat. But you caveat personal property, that basically means therefore that this person, these people, again having seen that they had paid the amount of shares held by them and there was nothing remain, therefore, notwithstanding the position and the weakness of the company, they shall be at no point of time be held responsible for the losses that is directed to the company. And that's why we said that indeed that could not be the case, and therefore there is a big separation between the company and the shareholders. I want to make that clear, and that should not confuse that if the company has no word, and then of course that means that there is no, that the liability is unlimited. The liability is not unlimited. Yes, someone asked, what about crystallization of rotting churches? Now, crystallization of rotting churches is basically at a time when now, for example, the company has been put in liquidation. And now if the company has been put in liquidation, then the floating charges must crystallize based on how much the company is going to make from the liquidation process, not to make as such what is their fireable assets. What is their fireable assets? And indeed, we are saying that it is at that point of time when the assets of the company are going to be made available. That's when these floating charges will crystallize. Crystallize, basically, they will come to a point of payment. But I want you to see the difference, as I've said, on the fixed charge. On a fixed charge, the moment the company is put into liquidation, it does not require for the whole process to go to liquidation, because already this person being secure, for him, the moment the company has already been put, he will just ask that this is not even part of now the assets, it is mine, because I had been given it in lieu of the money that I had provided. And therefore, this person will immediately remove. But for the person who has a floating charge, he'll have to wait for the crystallization. Crystallization basically means at that point of time when the assets are being disposed of, and then they are put together and see how much that each person is going to receive. And that's when we say the floating charges crystallize or come now to fruition. It comes to fruition at that point of time. Good. I have seen the person who has said yes, they come crystallized when the company is liquidation, and that's what exactly I've said. What happens when a company is liquidated? When the assets are not enough to pay all debts, is it possible to remove it in the register of the company? That's a good question. Now, the whole essence of company law is actually premised on the very question that you have asked. Now, of course, we are basically saying that there come scenarios when a bank, for example, has given a loan to the company, and maybe, for instance, it gave a loan of 100 million, and the company became broke, collapsed, and out of the assets of this company, maybe what the bank can get is only 20 million. And having maybe said that, or other maybe creditors also have been given not to satisfaction, but small as it was available. And therefore, the question is, what happens with this 80 that is remaining, that is unpaid, because all assets have been sold, but still the money is not sufficient? And we call that one an advantage. We call it an advantage, but again, you will ask, advantage from what point of view? It is an advantage from a member who had put his shares in this company. He has been earning profit, and things have become bad. Although there is 80 million that is unpaid, it does not touch the member. But the company will suffer to that effect the loss of 80 million, because there is nowhere they can recover it from. And therefore, to the company, to the bank, it's a disadvantage. But to the member, it's an advantage. And therefore, to this extent, yes, this company, if it has paid what was available to the debtors or to the creditors, and then, of course, the amount which could not be found, it is forfeited. You forget about it. And then, yes, this company can be removed from the register of companies, because for no good reason is it going to be in the register. And there is no way it can raise money, because already the assets of this company has been disposed and there is nothing that is remaining. And to that extent, the bank will suffer the loss, and all of those others who had given, to that extent they shall suffer the loss. That is the position of law. Yes, at what point of time can a liquidator, or at which appropriate time a liquidator should be appointed? Now, of course, depending on a number of factors, I want you to know that there is what we call compulsory liquidation, and there is what we call voluntary liquidation. Now, taking into account the possible aspects that can lead to liquidation, remember, liquidation is a process which leads to winding up. And therefore, the question is, at what point of time, which is the appropriate time that a liquidator should be appointed? Now, if I could pick a symbol, maybe a case to demonstrate, if it is a company that is unable to pay the debts, it's unable to pay the creditors, then the moment the creditors have gone to court to ask the court to declare the bank bankrupt, and if indeed the bank cannot pass the solvency test, then that bank is considered bankrupt, and immediately when the court has pronounced it bankrupt, then a liquidator is appointed. So that the interest.
Excuse me.
Yes, please.
Please, there is another class that is going on.
Oh, sorry.
Can actually summarize and end it by here.
Yeah, sure. Let me do that, and then I will share the materials later.
All right.
Thank you very much. So I just want, maybe for those, because of the interest of the other class that is picking up, and we are in a place it may not take place. What I'll ask, I just want to give you my number. Please, you can share. You can write the number, and then at an appropriate time, I can try maybe to handle those questions. But in the meantime, also, I will share this material through the host, and the material will be shared. So my number is 078. That is the local number, 078 34 666 21. I repeat once again, 078 34 666 21. That number, you can reach me through WhatsApp, and that aspect that I might not have dealt with, we shall be able to, if time will allow, we will look into it. Otherwise, I just want to thank you all for the cooperation and for the time that we've had together. At the same time, I take this opportunity to wish you all well as you look forward for your upcoming exam. May you excel, may you pass, and best of all the best is my wishes. Thank you, and I look forward again to hear from you if an opportunity be failed. Thank you very much.
All right, you can share the material through the email that I shared in the chat.
Yeah, sure.
Yeah.
I will do that.
Thank you.
Thank you very much, and have a nice time.
Thank you.